Good afternoon. My name is Anna Braun, and I'm the chair of the Minnesota State Board of Public Defense. It is October 30th, 2020. Due to the ongoing coronavirus pandemic, the board will be convening its board meeting via electronic and telephone conference today. Thank you all for your participation in this meeting. Board members, the chair would ask you that throughout the meeting, before speaking or making a motion, that you please identify yourself for the record. Board members, please, we will now take the roll call, and I would ask that you respond aye to signify your presence when Administrator Kyer calls your name. Administrator Kyer, will you please call the roll?
Board Member Darris?
Present.
Board Member Harris?
Oh.
Here.
Board Member Janetta? Board Member Janetta? Board Member Crew? Okay. Board Member Lee?
Aye.
Board Member Meyer?
Aye.
Board Chair Braun?
Aye.
Board Member Janetta? Board Member Croon? All right. I know Madam Chair, I know that they are, we're trying to get in. I don't know that they were able to, obviously. So I will go and check on their availability. I'll check with our tech staff.
Thank you very much. The chair's request to wait a few moments to allow additional board members to join us. I was unable to detect from my computer screen who was or who was not already joined in the meeting. If there's no objection, we'll wait a few more minutes to allow those board members to join.
Chair Restoris Brown, this is Eli Darris. It appears as though Board Member Kroon has messaged inside of the chat that he's present.
Oh, great. Thank you very much. Board Member Kroon, are you able to hear us?
Can you hear me? Hello?
Yes,
We can hear you.
Okay, so I just unmuted myself. I thought that the chair had unmuted me, but now I pressed the mute button, so I'm here. Thank you. Appreciate it.
Thank you, Mr. Kroon.
Madam Chair, this is Board Member Harris. Can you hear me?
Board Member Harris, I can hear you. I don't know if the rest of them can.
Board Member Harris, I can hear you as well.
Okay, fantastic. Thank you.
Okay, you're in the right one.
I'll have them call you.
Okay.
There we go.
I can hear you, Board Member Harris. Can you hear me?
Yes, I can. I can hear everyone. Thank you.
Thank you. Hello, Ms. Janetta. Thanks for joining.
I apologize. I was in the executive session, a meeting waiting to get, so I was in the wrong one. Apologize.
Thank you. Ms. Janetta, I had called the meeting to order, and Mr. Kyer had taken the role. Administrator, would you please take the role of the board members again?
Sure. Board Member Darris?
Present.
Board Member Harris.
Here.
Board Member Janetta.
Present.
Board Member Kroon.
Here.
Board Member Lee.
Here.
Board Member Meyer.
Here.
And Chair Braun.
Here. Thank you. The board welcomes today, excuse me, the board welcomes new board member, Mr. Eliza Darris. Mrs. Darris, if you would be so inclined, please share with us a little bit about yourself and a background.
Well, sure. Thank you, Madam Chair. So my name is Eliza Darris. I want to first and foremost thank all the community members who are present and listening. I certainly thank and appreciate the support that you all have shown me and the trust that you all have placed inside of me to exercise servant leadership in the various different stations and the various different roles that I've had over the years. Currently, I work for the ACLU. I coordinate our Smart Justice campaign. I coordinate with a lot of governmental and community stakeholders around criminal justice reform initiatives and things of this nature. I also work pretty deeply inside of local politics inside of the Twin Cities. And so that's just a little bit about me. Thoroughly interested to, be on this board and to really help to advance our state of public defense in preparation for any future challenges or prevalent challenges that we have today. So a little bit about me.
Thank you very much. We're glad to have you. The board members, you've all received a copy of the minutes from the board meeting of June 9th, 2020. Are there any corrections to the minutes? Hearing none, I would entertain a motion to approve the June 9th, 2020 minutes.
I so move. Board Member Janetta.
Thank you. Ms. Janetta has made a motion for approval. Do I hear a second? Second, Board Member Harris. Thank you. Board Member Harris has seconded the motion. The question is on the approval of the June 9th, 2020 minutes. For those voting in the affirmative, please say aye. For those in the negative, please say nay. And I will, because we're in this forum, have Administrator Kyer call the roll for that vote, please.
Board Member Darris.
Aye.
Board Member Harris.
Aye.
Board Member Janetta.
Aye.
Board Member Kroon.
Aye.
Board Member Lee.
Aye.
Board Member Meyer.
Aye.
Board Chair Braun.
Aye. Thank you. The ayes have it, and the motion is next item of business is 2022-23 budget request. The chair would call upon Administrator Kyer to present that biennial budget request.
Madam Chair and members, this is our biennial budget request to the legislature. It's kind of amazing that it's that time of the year again, but it is. I can say honestly, in the 30 plus years that I have been dealing with the legislature or dealing with the budget process, this is the, maybe not the worst one, but certainly the most uncertain situation that we dealt with. As of May of 2020, the last revenue forecast the state did, the state was showing a $2.4 billion deficit for the fiscal year that ends June 30th of 2021. On top of that, the state is showing a budget deficit of $4.6 billion for the budget period 2022-2023. That period starts July 1st of next year. That is roughly 9% of the state general fund budget. We all know the uncertainty surrounding the COVID-19 situation. Our chief public defenders have been dealing with that on a daily basis, frankly, in various courthouses around the state. But the other uncertainty, and the really big uncertainty, is the fact that the legislature hasn't dealt with this issue. Excuse me. They have known since May, as I said, about the problem, the budget problem this year. And at least at this point, despite several special sessions, the budget has not come up as a topic of conversation. We are hearing now that that may not happen until after the election, and even then, probably not until January, until there's a new legislature sworn in after the first of the year. Why that's important is obvious in terms of just the uncertainty, but also in terms of the budget process or the budget itself, where you now have only 6-month or potentially a 5-month window to make any kind of budget adjustments that the legislature may enact. And that is again something that not only creates great angst for those of us who deal with that, but a lot of uncertainty. And as I said, that is unique. I don't recall a time when there were the legislature, the governor were facing these kind of budget problems, and they weren't digging in to deal with them at an early stage. That's just the hand that we've been dealt, and we'll do the best we can to deal with it. As far as the budget request itself goes, again, talking a little bit about uncertainty. Normally, we would be asking you for additional lawyer staff, additional support staff. Going forward, again, we just don't know where this is all going to end up. And in the Chief Justice's words, kind of when do we get to the other side of this? It's not clear, obviously, how that's going to play out either nationally or internationally. So the thought was, as we went through this budget process, was it was a little difficult to ask for additional attorney staff, just because we don't know what those numbers are going to be going forward. In the past, we've always had a pretty good gauge as to where we've been and kind of what the growth piece might be over the next 2-year period. Excuse me, we just don't have that this time. What we do know is that we are extremely short-handed when it comes to support staff. Our investigators, our paralegals, our dispositional advisors. Right now, we are running with about 75%, of the recommended standards for attorney staff. We are running with approximately 62% of the support staff that the national and state standards says that we should have. So seizing on that was kind of an area we thought was an area that we could at least bring up to the legislature, at least talk about that with them. Again, I'm not under any illusions, and I don't think any of the chief public defenders are, that this is not going to be a difficult task and a difficult ask for additional money going forward. But we felt it was important that we at least put those issues out there. So in terms of the budget request itself, it really consists of 4 portions. One is the staffing increases. So we are asking for staffing of investigators, paralegals, and dispositional advisors to bring those levels up to where we are with our attorney staff, to that 75% level. In addition, we're asking for, or asking you to approve, one-time funding for temporary staff to get us through the bubble, if you will, of all the cases that have been delayed and will continue to be delayed. As of July, the Judicial Council had told us, or indicated, that there were somewhere around 10,000 felony and gross misdemeanor cases on a backlog. And as that number certainly has grown, A number of the courthouses have reopened since that time, but they're clearly not dealing with as many cases as they would have under normal circumstances. So we're asking you to approve one-time funding to get us through that bubble. In addition, we have collective bargaining agreements that will come up next July. We are asking that the board approve funding for step increases for those collective bargaining agreements, as well as a 1% cost of living adjustment each year of the biennium. The next piece is our cost of insurance. This is one we don't control, obviously. This is one where the Office of Management and Budget tells us basically here are the increases that we are projecting over the next 3-year period, and somehow you have to fund those. So the insurance cost piece is funding their projection over the next 3-year period of our employee insurance costs. And finally, as you all know, we have 4 public defense corporations that the legislature provides funding for and goes through our office. And we're asking for a 4.5% increase each year on their grant agreements or on their grant amounts. Madam Chair, that's the summary of the budget request. I will note for you that some of the correspondence I have seen from the executive branch or within the executive branch is that they are asking agencies for some priority-based budget items. They are asking for budget reduction scenarios, preparing for dealing with that budget crisis. And I would also note that the Judicial Council approved a personnel request not last week, 2 weeks ago, with a 0% increase the first year of the biennium and a 3% increase for their staff the second year of the biennium. The personnel increases that we are asking for, when you talk about the step increases in the COLAs, amounts to about 7.5% over the 2-year period on average. So the total request is just under $20 million for the 2-year period. It is about 9.7% over the biennium, over last year's biennium. With that, Madam Chair, I guess I would stand for any questions that board members may have.
Thank you, Mr. Kyer. Are there any questions from the board members? If not, I would entertain a motion to approve the budget request as stated by Mr. Kyer.
Herb Kroon, excuse me, so move. I make that motion.
Thank you. There's been a motion made by Mr. Kroon. Is there a second?
Second by Board Member Meyer.
Thank you, Justice Meyer. Board Member Meyer has seconded the motion. It has been moved and seconded to approve the 2020-23 biennial budget request. Is there any debate? On the approval of budget request, for those voting in the affirmative, please say aye. For those voting in the negative, please say nay. Administrator Kyer, will you please take the roll call on the vote?
Board Member Darris.
Aye.
Board Member Harris.
Aye.
Board Member Janetta.
Aye.
Board Member Kroon. I think you have lost Board Member Kroon. Board Member, Board Member Lee.
Aye.
Board Member Meyer.
Aye.
Board Chair Braun.
Aye. Thank you. The motion to approve the budget request is adopted. The next item of new business is the Personnel Committee. I would like to note, change the agenda. The chair notes that the Chief Public Defender for the 10th District, Ms. Murphy, had a personal family situation arise today and will not be present at today's meeting. As a result, her reappointment process will be postponed to a later date. The chair would also like to make a few remarks before calling on the Personnel Committee Chair, Ms. Janetta. The public narrative surrounding this appointment process has been one about speaking out for racial justice and fairness in the court system. Fair treatment in the criminal court system and client-centered representation have been and always will be areas that this Minnesota State Board of Public Defense and all of its staff of the board focus on and are dedicated to achieving. Any time that a board or an appointing authority deals with personnel decisions, it is a delicate matter. It is, in the case of a highly visible and public position, even more so. While the process is a public one, much of what the appointing authority must consider in any personnel decision is information that is private, personal data that cannot be shared publicly. While this can be frustrating for members of the public, this is done for the protection of that individual or the employee involved. Ordinarily, the board receives and considers personnel information and evaluation reports in executive session during these meetings because such information contains private personal data. This is the right of the employee and is for the protection of that employee. In this case, Ms. Moriarty has indicated that she would like to waive that right. So, Ms. Moriarty, are you indeed waiving the right to have your reappointment discussed in executive session today?
Publicly? Yeah,
Thank you.
yes,
You're waiving your right to have it privately discussed in executive session.
yes,
Thank you. You acknowledge that what ordinarily would be private public data about you will be discussed in a public meeting.
yes.
Thank you. And documents relating to this portion of the agenda are available for the public online at www.pubdef, so pubdef.state.mn.us. The chair would remind the assembly, this is done in the Personnel Committee, that while Ms. Moriarty has waived her right to private personal data being discussed in the public meeting, other employees have not waived that right. Therefore, all questions, comments, and remarks of the board members or others recognized by the chair should address issues in Ms. Moriarty's evaluation, should address her performance, which may include the investigation or reprimand of which she was the subject, and any letters she submitted in response to the evaluation or directed towards the board. The board has received communication from the public regarding this appointment process for the 4th Judicial District Chief Public Defender position. All of that correspondence has been accepted, read, and reviewed and considered by each one of the board members. So given the public interest in this matter, though it is not something we typically do in this forum, the board, or the chair would entertain a motion if the assembly believes that we should to take public testimony on the appointment process once we have debate.
I so move, Chair Braun.
I second, Molly Janetta.
The chair asks that the motion be perhaps a little bit more specific as to the amount of time and or I think we need to put some parameters around the public testimony.
Madam Chair, I would move that testimony is limited to 2 minutes a person. This is Molly Janetta.
Okay, and how long in total is the motion being made for?
For 45 minutes. 45 minutes.
Okay. I'm hearing that there's a motion on the floor that the board open up for public testimony on this issue for up to 45 minutes and allowing each person to speak approximately 2 minutes. Is that correct?
Chair Restovich-Vaughn, this is Eli Darris.
Yes.
I would, just looking at the sheer number of community members or assumed community members, we'll probably motion that we make that at least 60 minutes, so 1 hour, especially if we're going to give them 2 to 3 minutes to speak. Just the sheer number of them that would engulf that 45 minutes. And so I would say that we move it to about 60 minutes to allow for public comment and or public questions.
Thank you, Mr. Darris. Mr. Netta, you've made the motion now. There's a suggestion by Mr. Darris to amend your motion from 45 minutes to 60 minutes. Are you willing to accept that amendment as part of your motion?
Yes, I am. This is Molly.
Would you then state the correct motion for the record, please?
I move that the motion is that we allow up to 60 minutes for public testimony and limiting each individual remarks to 2 minutes.
Thank you. Is there a second?
Board Member Harris, I second it.
Thank you, Board Member Harris. It's been moved and seconded to allow for public testimony for up to for up to 1 hour, 60 minutes this afternoon, and to limit to approximately each person. The question is on the adoption of that motion. Is there any further debate of the board members with respect to that? Hearing none. For those voting in the affirmative, that is to adopt the motion to allow or to open up the public testimony, please say aye. For those in the negative, please say nay. Administrator Tyre will take the roll for the vote.
Board Member Darris?
Aye.
Board Member Harris?
Aye.
Board Member Janetta?
Aye.
Board Member Kroon? Board Member Kroon? Board Member Lee?
Aye.
Board Member Meyer?
Aye.
Board Chair Braun?
Aye.
Board Member Kroon? Okay. Madam Chair, I think you can move on. We'll see if we can get her back.
Thank you. The ayes have it, and the motion is adopted. I would like to announce at this moment then if anyone from the public wishes to testify today in this hearing later this afternoon, please send an email with your name, spelling your last name, and what organization you represent, if any, to Board of Public Defense at pubdef.state.mn.us. Thank you all. For the next item of business, the Personnel Committee will report on its recommendation for the Chief Public Defender appointment in the 4th Judicial District. The Chair recognizes Ms. Janetta, the Chair of the Personnel Committee, to provide the Board with the Personnel Committee's recommendation on that reappointment of the 4th Judicial District Chief Public Defender position.
Thank you, Madam Chair. The Personnel Committee met earlier today with Bill Ward and Mary Moriarty, and each of them presented their presentations, as well as the board has received the packets of memos from Bill as well as from Mary, and then another response from Mary, as well as a lot of public input. We've all read all these memos as well as all the public comments. Discussion followed at some great length. I guess I would rather that each board member at this part of the meeting would be able to articulate their points, but enough to say the discussion followed, and our recommendation to the board was that we recommend to the board, the full board, that the position is opened up for applications. if you would like me to flesh this out, or, well, I'll just wait for you. Oh. You're muted, Anna.
Thank you, Ms. Janetta. I believe you're making a motion to...
I will.
But I would ask you to do so formally for the record.
Yes, I will make the motion. The motion is that we recommend that the board we recommend to the board that the board open up the position for applications.
Do I hear a second?
This is Board Member Meyer. I second it.
Thank you. Board Member Meyer seconds the motion. A motion has been made and seconded to open up the position of the 4th District Chief Public Defender position for applications at this time.
Chair Braun, this is Eli Darris. Are you about to open it up for us to now vote on that? Will there be an opportunity for comment before then, or any comment before that for the larger board?
Thank you, Mr. Darris. I've just announced the question, and Ms. Janetta will retain the floor to begin debate, and then the board members will all have an opportunity to debate that issue extensively. Thank you. Ms. Janetta.
Okay, well, I wanted to start with basically laying out kind of the order of how events have transpired in this, since I was a member of the Personnel Committee and have been for quite some time and have been in on this issue from day one. And I want to start with the initial thing that happened was more than one employee in Mary's office came forward with some serious complaints about Mary's behavior, and they were serious enough to be brought to the board's attention by Bill and Kevin. Now, because we've gone into a public setting and Mary has waived her rights to privacy, other people haven't. So I'm not able to really discuss in full the nature of any complaints. I'm just telling you that this is part of the history of what happened here going forward. They brought these concerns to the board. At about the same time, Mary appeared before a Hennepin County Budget Committee meeting, and in her remarks said that we agreed that we were a failed experiment, the state system was a failed experiment, and requested that the county take the district back to county status. Now, keep in mind, 3/4 of the employees of this district are state employees. Only a quarter are still county employees, as we've moved to transition over about 25 years to make them part of a state system. So we wanted to call Mary in and talk to her about both of these issues. The board authorized the Personnel Committee to sit down with Mary and discuss both issues, which we did. The answers from her and the complaints from the other side, there was little common ground. So at the end of this, the board authorized us to start an independent investigation to see where the truth lied. You can't just ignore employee complaints. You can't just ignore Mary's response. Somewhere in there, we're trying to figure out what happened. So the investigation began, and Mary had provided a list of people to talk to as well, and that's how that went. So we, as a board, placed Mary on a fully paid administrative leave, which in my 30+ years of human resource management is a standard procedure of how to proceed when a complainant and the person being complained about are very far apart in what they say has transpired. After the investigation was complete, the board met, talked to Mary, and at the end we determined that we should do a written reprimand outlining areas in which we felt that her behavior and job performance needed to improve. Meanwhile, in that time, Mary had spoken to the press after meetings, and we were unable, as personnel issues, to speak publicly about any of this. So from the very first public information about this situation, it was one-sided and I believe did not at all accurately depict what the actual issues were. After the written reprimand was given and Mary returned to work, we're now forward here assessing whether or not to reappoint her. I just wanted to bring that timeline forward so that we would all understand the order of events of what has happened so far in this. I would then relinquish my time for others to ask questions, and then I will as well. I will do that as well.
Thank you. Is there any other board member that would wish to begin the debate?
Sure. So I guess I don't have any questions. I would have a statement that I would make, but I don't have any questions based off of the timeline that's laid out. So I'm not exactly sure, Chair, how you would want us to proceed forward. Should I open up with my statement, or should I be responsive to the call for questions to the timeline?
Thank you, Mr. Daris. I would, Chair, recognize you to speak as to whatever issue you wish to, as pertains to the motion pending before the board.
Excellent. Well, thank you so much. And I will say good afternoon, Chair Rustovich-Braun and members of the committee. I also want to again acknowledge and thank all of the community members who are present as well. I recognize that I am new to this board, but I want to assure all of you and anyone who's listening today that I've spent considerable time becoming familiar with the laws and the policies that govern these proceedings. And I would say the universe of factual information that we are here to consider today. I also listened to Chief Moriarty's statement to the Personnel Committee this morning, and I've listened to all that has been said by Mr. Ward and also my fellow board members. I would say here are my views based off of that. First, I think it's important for us to take a step back and to revisit why it is that we as a board are here in the first place. And I would say, according to our mission, our primary job as a board is to, and let me pull up the quote, is to provide, quote, excellent criminal and juvenile legal defense services to indigent clients through an independent, responsible, and efficient public defender system. That's unquote. To accomplish this, we as a board have identified 5 individual goals. We are to ensure that Minnesota Public Defense System, 1, provides client-centered representation to those it serves. 2, nurtures and empowers its advocates. 3, provides top-notch training to its lawyers. 4, recruit and retain a high-quality and diverse workforce. And 5, ensure that the PD system in Minnesota is a robust and respected partner in the criminal legal system. Our secondary task is to appoint, and in this case, reappoint chiefs in each of our 10 districts to further our mission and the 5 goals that we as a board have identified. We are here today to make a reappointment decision about one of our chiefs. One of them had an emergency, and so, of course, that one's going to be continued, but to make a decision about appointing one of our chiefs that aligns to our mission and also to our goals. So how do we make this appointment decision? We have at least 2 forms of guidance. One is Minnesota Statute 611.26 that governs the appointment of chiefs, And we also have a policy that was written by this particular board back in May of 2015. The statutory process as 611.26 reads, it tells us, quote, when appointing a chief district public defender, the State Board of Public Defense membership shall be increased, to include 2 residents of the district appointed by the chief of the district to reflect and this is an important part, to reflect the characteristics of the population served by the public defender in that district. So the legislature recognized that the best way to determine whether PDs in a particular district are providing client-centered representation and are empowered as advocates is to ask those most impacted by the work of that office, in this case, namely the public. In fact, the statute also requires recommendations, this is a quote, recommendations from the public, the local bar association, and the judges of the district, unquote. And again, the emphasis is on the public, and secondarily, input is from the bar and the bench. And then there is also the May 2015 policy. The policy restates this board's 5 objectives and then lays out a process for evaluating chief PDs. It mentions input from judges, prosecutors, PDs, and the chief administrator. I will say more about this. I'll say just a bit more about that a little later. But I think it's notable that despite the very clear emphasis in the statute, this policy does not require anywhere input from the public. I do want to commend the Madam Chair for opening this particular process up and allowing for public input, including allowing a section of this hearing to have the public directly participate in this process. But I would note that that is not part of the 2015 policy. So, given our mission, I just have a little bit more, but it sounds like I'm being asked a question.
No, thank you, Mr. Daris. I would just ask that the board members stay with the pending motion that is before us and that debate be germane and pertinent to that issue.
I totally agree, and I believe that it is. Thank you, Madam Chair. So given our mission, our 5 objectives, and these 2 forms of guidance, how do we best evaluate whether a chief PD and her office, in this case, are providing client-centered representation, whether her staff is nurtured and empowered, whether she is providing top-notch training, recruiting, and retaining the best lawyers, and ensuring that her office is respected? How do we do that? First and foremost, we must ask the public what they think. The legislature recognized that public defense is fundamentally about the public, and so must we here. Do members of the public believe that a particular office, and by association, the chief of that office, are fulfilling the 5 goals that the board has identified as paramount? We will look to their letters, their emails, today their public comment, their testimony. We might also look to local leaders and advocates, and particularly those who work directly with the clients of this office. How is this office performing? That includes civil rights advocates, criminal legal system reformers, community-based organizations, and racial justice advocates. Third, we might also look to an objective and independent evaluation of that office. What do those organizations whose purpose it is to determine the quality and effectiveness of a PD office across the country think of that office in question? And then finally, we would then canvass the sources identified in the May 2015 policy that we have adopted. But I would ask whether county attorneys and county administrators are the best measures of a chief PD's performance in a system that is inherently adversarial. If public defenders are doing their jobs and doing them well, if they're doing the job well, they're not always going to be making friends, I would say, on the other side of the courtroom. We all know this. If the rationale for having a separate policy that basically ignores the public and relies on input from adversaries in the reappointment process is that somehow qualitatively different than the appointment. We should acknowledge that we are effectively disenfranchising the people of the 4th District who rely on the Hennepin County Public Defense Office over 2 letters. Their chief is their chief, whether she is appointed, reappointed, or plucked from the sky. They must have input. So what we have learned about the performance, so what have we learned about the performance of Hennepin County Chief Public Defender Mary Moriarty and her office? To date, we've received about 175 letters from members of the public, from everyday people to civil rights advocates, community leaders, to people directly impacted by the work of Chief Moriarty's office. Every single one, without exception. I haven't read any single email, and I don't believe you all have as well, from any community member that has not called for the reappointment of her as chief. We've also received letters from elected officials. This includes Sheriff Hutchinson of the Hennepin County, Representative Ilhan Omar, Mayor Jacob Fry, and a number of members from the Minnesota House and State Senate, all calling for her reappointment, and some even praising her as, quote, a great partner and ardent justice defender. We've received letters of reappointment, again, from Chief Arredondo, from Medical Examiner Andrew Baker, and many others. We're also fortunate to have for our consideration a comprehensive evaluation and report of the Hennepin County Public Defender's Office from a nationally respected and independent organization, which is the National Center for State Courts. To quote directly from the evaluation, quote, under Ms. Moriarty's vision and leadership, the Hennepin County Public Defender's Office operates at a high level of excellence and delivers a notable level of service to their clients, unquote. These conclusions are echoed and bolstered by over 50 letters from individual public defenders and public defense organizations and law professors and system stakeholders from across the county, and actually from across the country, quite frankly, all praising Ms. Moriarty. And we've also received at least 50 letters from members of Chief Moriarty's own staff. Every last single one of them have been positive, and that's without exception. Some even sent me private emails expressing fear of retaliation. As a board member, I want to be very clear. I can assure them that I will work vigorously to uproot any of that energy from this department. Intimidation will not be tolerated. To my knowledge, we have not solicited or received any input from the Hennepin County Bar Association, nor have I seen any input from the judges myself, although I do believe that our subcommittee did receive some input from judges. If I can summarize this universe of input, I would say that it describes Chief Moriarty and her office as in the most positive terms. Her office provides excellent client-centered representation. Her staff is of the highest quality and is empowered and well-trained. She and her office are respected across the country. And most importantly, the public has unequivocally expressed its full confidence in and support of Chief Moriarty. And I can tell you from experience that, quite frankly, that's not often the case, that members of our most impacted and marginalized communities, those whose voices typically aren't amplified in the halls of power, come out in clear vocal support of a chief public defender. Now, for a moment, I do want to pause and, against this backdrop, let us consider the memorandum from State PD William Ward recommending against Chief Moriarty's reappointment. I think it's critical that this memo, I think it's critical to point out that this memo relies not on input from the public, civil rights advocates, community leaders, people directly impacted by the work of Chief Moriarty's office, or elected officials, or even the National Center for State Courts, or other public defense leaders across the country, or the Hennepin County Bar Association, but instead, 4th District staff, 4th District bench, the Hennepin County Attorney's Office, Minnesota City, the Minneapolis City Attorney's Office, Hennepin County Corrections, Court Administration, Hennepin County Administration, and Chief PDs from across the state. Again, I understand that some of these sources are identified in the May 2015 policy that we've adopted. But again, I would ask that this board consider whether these are the sources whose input should control our decision today. Or are we, the State Board of Public Defense, really going to base a decision to reappoint one of our chiefs on what certain county attorneys have thinks? With respect to the memo itself, I'm deeply troubled by the fact that each and every single source of information remains anonymous, and the volume of inputs is not quantified. And as I stated previously, they're not annotated. I'm also troubled by the fact that in many instances, the memo provides summaries of input from these sources and not direct quotations from the sources themselves. I've asked repeatedly for the sources of the information in Mr. Ward's memo to be identified, or for Mr. Ward's summaries of their statements to be stricken from the record. Turning to the substance itself, unlike the more than 175 letters that we have received from the public, from independent evaluations and et cetera, very little information contained in Mr. Ward's memo speaks to the 5 goals this board is charged with fulfilling. Instead, the majority of the information, it seems personal in nature and says almost nothing about the performance of her office. At worst, it describes a chief PD who does not get along with everyone in an inherently adversarial forum that is our criminal legal system. Even then, however, I would note that elements of the memo are quite positive. In fact, nearly all of the staff that were reported in the memo all had positive and glowing things to say about Chief Moriarty. Let me finish by returning to where I began, to why it is that we as a board exist in the first place. To me, this is about more than just an employment decision. It's about the quality and the character of the state of public defense in Minnesota. It's about whose opinions matter when we are evaluating the leaders of this system. I'll be honest, this is very personal to me. Of all of us, I am the only member of this board, most likely, who has ever received the criminal defense services of a public defender for a felony case.
Thank you very much.
And that's significant. And I'm almost done. I just got 3 more minutes and I'm concluding. But that's significant. I just don't want that point to go by. People in my position typically don't come out in defense of and speaking up on behalf of public defenders because of our experiences. And I'm literally, most likely, the only board member who resides in South Minneapolis, literally 3 minutes walking distance from the scene of George Floyd's homicide. I've also sat as a justice partner across the table from Chief Moriarty as she was in attendance. Also in attendance was the county attorney's office, representatives of both the bench and court administration, community leaders, and other critical stakeholders as we all worked in collaboration on big countywide projects and systems reforms. I'm likely one of the only board members who has repeatedly had multi-departmental, multi-agency, multi-communal meetings with Mary or her staff as we work to advance much needed justice initiatives that our community has been crying out for. This community has resoundingly called for Ms. Moriarty to continue to serve as their chief, and I think we absolutely should heed that. We should not, in the midst of massive social upheaval, and in the middle of a deadly global pandemic, remove the chief of the largest district who is steeped and deep in high-level reforms, who's working with multiple justice partners. I'm almost done. Again, of the more than 175 letters we received from the public, not one single letter has called for her to not be reappointed. And that's significant. We must move to reappoint Chief Moriarty. I urge all of you as my colleagues to hear my voice. I have direct experience in the community, and many other major justice partners have also spoken here, and I'm echoing what many of them have said. I urge us to vote to reappoint Chief Moriarty in opposition to the motion that was made.
Thank you, Mr. Darris. At this time, the chair would offer Ms. Moriarty the opportunity, if you would like, to address or respond directly to the Personnel Committee's recommendation. You may have a period of up to 30 minutes if you choose.
Oh, I wasn't aware that I had the opportunity to address you. After the recommendation of the Personnel Committee this morning, I was trying to decide, I mean, I guess it seems surreal because it's hard to know, how do I think about the idea that I have pretty universal support, almost universal support from our office, from our community, our staff. Our office is functioning at a high level. We're considered one of the best public defender's offices in the country. I felt, I actually felt I'd let people down. I got a text, I saw a text or a tweet from somebody I didn't even know who was talking about my advocacy, about race. I'm going to be really honest here because I, at this point, really have nothing to lose. I feel as though this is so Minnesota. And when I say that, what I mean is that we don't talk about race. We don't. When we try to talk about race, when we try to talk about problems in the system, about mass incarceration, frankly, about our county attorney's office not handing over Brady material to our staff, the system tries to shut us down. And to have my own board, the Board of Public Defense, which is supposed to be about high quality advocacy for our clients, is astounding. To have this board not even, and I understand that's going to happen now, I didn't even know, I doubt that the public even knew that you didn't solicit the opinions of the public, of our community, is kind of, it says a lot. It speaks volumes. It speaks volumes to our community, particularly our marginalized communities who have been torn apart by the systemic racism in this system. But until now, they haven't been asked their opinion. And it appears as though, at least the Personnel Committee is voting to completely ignore, and I had no idea this, you've received 175 letters of support from people in the community, organizations, our office, and you have an independent evaluation that our office is one of the best public defenders offices in the country, and you are going to ignore that and essentially fire me because I am unafraid to speak out about issues of systemic racism. I am unafraid to talk about the fact that a county attorney sat on a panel next to our chief public defender and called our clients thugs repeatedly, and said nothing. And yet I found myself in front of the Personnel Committee having to answer for that. What about the voices of our office? You have received overwhelming, and I didn't know this, you've gotten, what, 50 letters from our office, from our staff, all supportive. You know, from Mr. Ward's memo, he got 27 letters from our staff and 25 were supportive. When do public defenders ever agree on something like that? And yet you are willing to dismiss that. You are willing to dismiss the voices of the people who work in this office, who aren't paid nearly as much as county attorneys are paid. Yet they do it every day because they care passionately about our clients. So you're willing to dismiss the voices of our community, the National Center for State Courts, our staff, for what? Mike Freeman, who said he was going to go after my job, and who hates the fact that I will speak out publicly and criticize his office. Mark Thompson, the Assistant County Administrator, who said he would discipline me for wearing a Black Defenders Matter t-shirt because it was biased. Two members of my staff, by the way, who did come forward to complain about the fact that I talked about race. They both told me that. They both told me they didn't like the fact that I talked about systemic racism and systemic issues. They valued their relationships with the county attorney's office more than they valued our clients. And they are no longer working here. The culture of fear was a lie. You now know that. The allegations that they made, like I addressed this morning that I tweeted, retweeted something from Brian Stevenson, talking about how we had to recognize our legacy of lynching. That's what one of the allegations were in the employment, in the Personnel Committee. And as I said this morning, I have never had a performance review. In 6 years as Chief Public Defender, I've never had a performance review, ever. And I will go back to Mr. Ward's memo. I wouldn't even consider that a performance review because he didn't circle back to me to talk about some of the anonymous things that people had said in there, which I can tell you aren't true, and I could have provided you with documentation of it. His memo says, well, let me take a step back. I had this reprimand, and it was based on 3 grounds: that I made an unauthorized statement to the county board during my budget presentation, which was in response to a county commissioner asking me. I was not collaborative enough with justice partners, and my personal and public social media accounts were too intertwined. Those are the 3 bases on which I was disciplined. All protected activity, by the way, First Amendment speech, which is why I have repeatedly said, and my lawyer has said, that it was illegal. That was why I said that. But I did try to abide by the conditions, even though it put me in jeopardy of being fired when I spoke to the newspaper about how the judges reopening was unsafe for our staff and our clients. And then I found myself in a meeting with Mr. Ward and Mr. Thompson. Mr. Ward told me that I got a complaint. He got a complaint from Justice Partners that I spoke to the paper about the safety of our clients and staff, and that I needed to concern myself with their hurt feelings. And Mark Thompson told me in that same interview that that's just not the way we did things in the county. We keep things away from the public. So make no doubt about this. This is about me speaking out on matters of public interest to our community. Things that our community wants to know about mass incarceration, systems, systemic systems, racism. That's what I talk about. And they don't like that. And they don't like that. One of the things Mr. Ward's memo said was that I had made no effort to repair any relationship, which was completely not true. Because as I wrote in my memo, and you know, one of the highlighted issues had to do with my interaction with somebody at the Criminal Justice Coordinating Committee, whom I then reached out to repair our relationship. And we now have a working relationship. He is a justice partner. But none of that was pointed out by Mr. Ward in his memo. I was accused in that memo of being insubordinate. Why was I insubordinate? Because I asked the county if the county would help us onboard 5 people to whom we made offers, and then I was told that we couldn't bring them on board, even though that they had moved here, taken the bar exam, and relied upon our continued representations over the summer, that they still had jobs. And I suddenly received an email from Mr. Kyer about 3 weeks, something like that, before they were to start, that we couldn't onboard them because it wouldn't be fair to them and because of the budget situation. I tried to find out from Mr. Kyer what he meant by it wouldn't be fair to onboard them, saying that it seemed to me that hiring them, giving them jobs, a paycheck, training them, but being clear with them that they could have to be laid off was fairer to them than telling them their start dates would be delayed for 60 days and then maybe having to rescind their offers. And he finally told me that what he was concerned about, his interest, was that if he had to lay them off, he and you would be out severance and insurance. And on hearing that, I thought, okay, maybe we can figure something out. So I asked the county, who you know generously funds us, but can't hire, or we can't use their money for full time. I asked them if they would consider allowing Mr. Kyer to keep, well, let me take a step back. You know that you have to reimburse the county for a certain amount of money for county personnel costs. And so I asked the county if they would be okay with allowing Mr. Kyer to withhold that amount of money if they had to lay off, if we had to lay off those 5 people. And the county was open to it. So Mr. Thompson set up a meeting with Mr. Kyer, Mr. Ward, and me, and David Lawless, the chief financial officer. I raised this issue. David Lawless from the county said to Mr. Ward and Mr. Kyer, she's being flexible and reasonable. Would you consider compromising and maybe bringing on, 1 or 2 of those lawyers? Mr. Ward said they would think about it, and ultimately Mr. Ward and Kyer said no. They rejected the county's help in onboarding those 5 people. And now, when I was shocked when I saw Mr. Ward's memo that I am being accused of being insubordinate for having asked And I mentioned this morning that there's a double standard here, a complete double standard. I think anybody else in my position who had spoken to the county to say, hey, can you help here? Here's a creative solution, would be applauded for that. Yet I am being told I was insubordinate for even asking that. I mentioned this morning that there's a double standard here about me, quote unquote, not getting along with justice partners. I outlined, and some of you seem to have questions about this, there are a bunch of other chiefs on here. Mr. Ward has repeatedly bragged about the fact that Justice Gilday hates him. Ask the chiefs here if you have any question about that. He has bragged about, well, Mike Freeman wouldn't speak to him for a long time. And Tony Cornish would leave meetings if he showed up. In fact, Tony Cornish, who is the head of the most important committee to this board, told Mr. Kyer that he would leave if Mr. Ward showed up with him. And as I said this morning, I don't raise these issues to be critical of Mr. Ward. We, as public defenders, need to take stands that other people aren't going to be happy about. Justice partners, as defined by judges, prosecutors, county administrators, are not going to be happy with us. That's part of our job, the same way it is for us to speak up on behalf of our clients every day. But why is a different standard being applied to me? Why is a different standard being applied to me when it comes to justice partners? And one of the things I pointed out this morning is a different standard also when our chief public defender in Ramsey County was held in contempt and scoffed at the notion in the newspaper that we're all supposed to get along. So there is a double standard here. There is a double standard here. And one of the things I did ask about this morning was on what am I being judged on? Because as Mr. Darris pointed out, 4 of the 5 goals that you have set out for me have to do with the quality of the defenders in our office, and Mr. Ward doesn't address a single one of them. He doesn't ask justice partners, by the way, how is the advocacy in their office? And it kind of goes back, because I've heard this talked about a couple of times. When I was summoned before the Personnel Committee, there was an allegation there that I couldn't get along or couldn't collaborate with justice partners. And it really confused me because I have expanded our collaboration with many, many justice partners. And so I came up with a list that was almost 2 pages, single space. And I gave that to the Personnel Committee. And now I have been accused, this has come up a couple of times, of Mary Moriarty gave us a list and some of the people on this list didn't say good things about her. Well, let me tell you some of the questions that were asked in the investigation. And the reason I put those people on the list was because we had collaborated together. And as I pointed out in my memo, I put former Sheriff Stanek on the list, not because we had a good relationship or he liked me, but I did a video for him so he could use it for community outreach. I was on his crime lab advisory board. I expected the investigator or Mr. Ward or whoever to ask those people on that list, tell me about how she collaborates with you. Instead, those people were asked, do you trust her? Has she ever crossed a line? They were never asked about collaborations with me. That's why you saw what you saw in the investigation report. It wasn't about collaborations, it was about questions like that. And I, in good faith, gave this list to the Personnel Committee thinking that an investigator would ask about my collaboration because I am able to collaborate with plenty of people. And most of the people on that list, including Sheriff Hutchinson, Chief Arredondo, the mayor, city council members, so many more I could name, were never actually even talked to. They were never, ever talked to. So I I guess I'm coming across, I feel like sounding very angry in a way, and I guess I am. I feel as though in the era of after George Floyd's murder, I am the head of one of the finest public defender's offices in the country. And that's not due to me, it's due to the passionate, wonderful people we have here who litigate creatively. That is our office. And after George Floyd was murdered, there was a national public defender march with community. It was a march in solidarity with community members. And I didn't organize it because I was afraid I'd be fired by Mr. Ward after that reprimand. And it was a grassroots movement with our office. And for the very first time, community members marched with our office for the very first time. And I was so proud of that moment because it meant that we are finally gaining some trust with our community, that our community members were willing to march in solidarity with us. And we had some formerly incarcerated men who commented about, hey, we're going to be watching you guys. You better keep up that advocacy. But what I think is being lost here is that we've never had the trust of our communities, by and large, because we're perceived to be part of an oppressive system, because we have been part of that. But it is through partnerships with our community members and our community organizations and speaking the truth about how they have been oppressed, even here in Minnesota, where we have a very hard time talking about race. In the meetings I've attended since George Floyd was murdered, what I had hoped after George Floyd's murder was that there would be a reckoning for every single one of us in the system, so that each of us looked at the role that we played, including the public defender's office. But all that I have heard from county people is that it's too bad that the Minneapolis Police Department makes us look bad, and that we should congratulate each other on the fine reforms and the fine job we're doing. And that's not okay, because that's not going to mean we're going to get to any reform. So this, in a sense, isn't about me at all. In a big sense, it's not about me at all. It's about our community. It's about our staff. It's about whose voices you listen to. Is it Mike Freeman? Mark Thompson? Are those the people that are important to our community, the people who don't think we should be talking out of turn and keep our stuff inside so that the community doesn't really know what's actually happening in the system? Because that's the message you'd be sending if you remove me. And as I said, it's not about me. It's about our community and our staff. And so I know what the vote was this morning, but I am asking you to reconsider that and to reappoint me. By the way, I would love to work with the Board of Public Defense on salary parity. I would love to have that happen. I really would. When I said that the county, in answer, by the way, to a question that the county should take us back, was because we had some meetings, you had meetings as a board, and people made it clear that there was never going to be enough money to have salary parity with our office and the county attorney's office. That is why my answer was the county should take us back. I think the state takeover was wonderful for most of the state. I think it was fabulous for most of the state, because if you remember, my father was a public defender, a career public defender, a winner of the Durfee Award for excellence in public defense. I know what it's like to be a public defender in greater Minnesota. I care about public defense in greater Minnesota, and so the state takeover was a good thing. it was not a good thing in terms of the salary parity for our staff. And if I could find a way to make that happen in the state system, I would love to have that happen. I would love to have those conversations and have that happen. So this is just such an important decision. And as I said, it isn't about me. It is about what message the State Board of Public Defense is going to send to our staff and to our community. And I am asking you to reappoint me. Thank you.
Thank you, Ms. Moriarty. We appreciate your comments. Board members, the floor is open for discussion and any questions relating to the recommendation, and I would recognize any board member who has not had the opportunity to speak yet.
Well, I have a few comments. Herb Kroon.
Thank you, Mr. Kroon. The chair recognizes you.
Mary, unfortunately, this is about you. And there's a fundamental difference of opinion, between how you perceive this and how we perceive this. But in my opinion, it's about your effectiveness as an administrator and your ability to work with the State Board of Public Defense. And all of the things that the 4th Judicial Public Defender system has done are wonderful. And it makes this decision all that much more difficult. Am I frozen? Can you all hear me?
Yes.
Okay. Anna's image is frozen, so you can hear me. Okay. Anyway, it makes this really hard because I remember 2 weeks before, Mary, you went before the Hennepin County subcommittee. You gave a presentation to us, and I was blown away at all of the effective things that you and the 4th Judicial District Public Defender system has done. It has been exceptional, and it makes this really hard. It really does. And by way of background, for people who don't know me and my relationship with Mary, I am a former public defender from the hinterland. I am practicing in Mankato, and I was a public defender in the 80s and 90s. And I had the privilege of working with Mary's dad, a wonderful man and a wonderful lawyer who we all looked up to. And Mary was an intern of mine. She was in college, and I was an attorney. She helped me on a rape case. So I've known Mary a long time. I've always liked Mary. And that's what makes this really hard for me, too, to have to say these things. But I have to share that I am most concerned about her relationship with her supervisory staff. 2 people who were key to the success of the 4th District Public Defender system resigned because they could not get along with her. And I think it's deeper than what Mary pictures it to be. It wasn't just about their difference of opinion with her about going to the public about racial issues. I don't know if I'm at liberty to say anything more than that, but there were deep divisions that she had with them. And of course, there was the incident at the Hennepin County Board meeting, which that is really significant to me because to me that represents insubordination. She made comments about asking for Hennepin County to take us back without clearing that with the public defender, the state public defender staff or the board. Just shocking. And further, we know now from her 2 staff members that she intended to make those comments all along. And that is just a key to me as to why I cannot support her reappointment. I want to add that we are now seeing tremendous hostility between Mary and Bill and Kevin, and I don't know how they can function as a team. You know, that's what we expect. That's what all the other chiefs do. They work together with Kevin and Bill, but now it has become so fractured that I cannot imagine us going forward. So it is, Mary, this is about you, unfortunately. And I appreciate everything that you have done to raise issues about racial issues and racial consciousness. I think those are important things. But as an administrator, as to someone who can work in our system in terms of internally, I can't see you being effective doing those things, and I cannot support your reappointment. Thank you.
This is Board Member Duchess Harris. I would like to say something. Can you hear me?
Yes.
Yes.
Okay. Am I recognized?
Thank you, Duchess Harris. Ms. Harris, you are recognized by the chair. I apologize, I was on mute. Thank you. Go ahead.
It's fine. All the technology is complicated. I just wanted to say that the primary reason that I am in support of the reappointment of Mary Moriarty has to do with what I see as concern with the process of the fact that she did not receive feedback on her performance for 6 years. I want to say that in this context because that is something that I have stated previously where there were not members of the public and Ms. Moriarty was not present, but I need for the record to reflect that I find that to be concerning. And those are my comments.
Thank you, Ms. Harris. Any other board member?
Madam Chair, this is Board Member Janetta. Is it possible for us to hear from Bill Ward again, or in this setting rather than the personnel meeting?
Absolutely. The board, Ms. Janetta, if you would like, or to ask him a specific question or to open it to Mr. Ward, that's appropriate.
Mr. Ward, I just wanted to, you were able to talk in our personnel meeting, and then Mary was able to respond. And it seems like Mary was able to talk, and I just think that maybe the full board would want to hear what your comments are in response to her, and both from this morning.
Well, Madam Chair, Board Member Hagen, you know, it's very hard to anticipate how to deal with the negative, right? There have been a lot of statements made through the conversation by Ms. Moriarty, not only attacking my credibility, but attacking my leadership. And, you know, that's her choice to do that, right? Ultimately, some of the ruminations that have gone forth are absolutely untrue. As Member Kroon just said, how two people perceive something, I've never seen it so 180% different from the same conversation or the same scenario that I was in. I'll give you an example. Ms. Moriarty is absolutely firm that somehow this is all about her speaking up about race. I have been a state public defender and a chief public defender in this agency since 2001. We all speak up about race. That's what we do. And this idea that somehow the board not appointing Ms. Moriarty because it somehow is not in favor of speaking out against the systematic racism and injustices, I really do think is a demeaning statement, not just to me, but to this board. Ms. Moriarty pins her argument on this bail hearing the bail symposium we were at. Yes, I was there. And Mary, I remind you that there were 4 people on that panel. The 4th person was retired Judge Lucy Wieland. And that's the 4th person. Yes, Mary, she was. I could see her head shaking. She was sitting right next to me. Next to her was Mr. Orpett, and next to her was Ms. Housley. And after Mr. Orpett made his statements, Ms. Housley thoroughly and in good in a good confrontational style told Mr. Orpett the word choice he's using and his actions and words were inappropriate. It was handled well by Ms. Housley. Then you made your statements, and you did make your statements. You're right, I didn't say anything. Ms. Housley did, then you did. And I don't know how many times I can tell you, this was never a subject of the Personnel Committee. The Chair Hagen is here, Dan Lee is here. They will tell you this was never, ever brought up during the Personnel Committee. It was never brought up as part of the investigation. So your idea that somehow it's centered on that based upon something that a deputy commissioner told an investigator is simply unfounded. It was not something that I discussed with the board, ever.
It's part of the investigation.
I understand that, but you keep saying that it was brought up by me to the board. It was never a part of the initial discussion with the Personnel Committee in December. I've never talked to any of the board members about that particular moment, ever. It never came up for me. I understand you perceive that to be the case, and somehow that's how we keep getting down this road, and the narrative that this is about you speaking out about racial injustice. It simply isn't true. I don't know how many times they can say the same thing. It is about questionable management decisions. It's about inability to work professionally. I've never suggested to any chief, including you, that we needed to get along just to get along. What we need are professional working relationships. That's what we need. And what we have here,
Excuse me, Ms. Moriarty. Excuse me, Ms. Moriarty. Your comments are out of order. This is Mr. Ward's opportunity to speak. Thank you.
What we have here is a situation. It's not about getting along with the stakeholders. When I have the stakeholders telling me they don't trust you, they don't trust being in the same room with you because you basically throw a hand grenade and then walk out the door without solutions. The conversation you continually refer to between you and Mr. Thompson and I was in an effort to establish positive working relationships. That's my job, to help you work off of the reprimand that the board issued. The goal there in that first conversation, one of the things you said was, I thought we were going to talk about the reprimand, which was never the intention because it's a private matter. And two, the idea that I was going to, mention that about getting along better. What I told you specifically, I asked you about the comment to the newspaper.
Chair, point of order. This is Elijah Darris. I'm going to ask that you have Chief Public Defender Bill Ward refer his comments to you and not directly to Chief Moriarty.
Thank you, Mr. Darris. The point is well taken. Mr. Ward, if you'd simply speak.
Absolutely. Absolutely. The conversation that was had with Ms. Moriarty and myself and Deputy for Public Safety for the county was to address the relationships and rebuild those relationships. That was the purpose of it. Mr. Thompson, without a doubt, said that, hey, we got to keep that stuff in-house. I didn't condone what he had to say. I very much said the letter that Ms. Moriarty wrote was thorough and on point about the safety measures about COVID. I asked specifically of Ms. Moriarty, do you think that by going to the press before having worked out all of the solutions on COVID helps in the endeavor on those relationships? That's what was said during that conversation. Ultimately, I knew that this was going to be an agenda about me and my leadership. I knew that was going into it. I knew that board chair when it became a public meeting this morning and this afternoon. I accept it. If that's what it wants to be, and as I said this morning, not taking responsibility and blaming me and blaming Mr. Kyer and blaming everybody else, that's what you have. Ultimately, my goal always, Madam Chair and board members, is to protect this board. I believe in this institution. I came here from another jurisdiction because I believe in this institution. I believe in the independence of this board. I believe in it not being political. I believe in the oversight of this board to make sure that we all follow the rules, the guidelines, and the bylaws that you set forth for us. When we are appointed for these 4-year contracts, we have obligations to follow. If they're not followed, then ultimately we suffer those consequences and potential repercussions. That's what I believe in. I believe this board did a thorough investigation when it needed to. Without a doubt, there were concerns regarding people leaving the office. that they did not want to ever be announced who they were. They wanted anonymity. That ties people's hands. There's no doubt about it. But ultimately, when the investigation was done, it was thoroughly done. The board insisted on it being thorough and fair, which is why you hired an outside investigator, and ultimately put Ms. Moriarty in a paid suspension. I completely agree with that because I didn't want the tone or the lens to be that somehow this was me against Ms. Moriarty, because it never has been. I have a job. My job is to help run this agency. I'm lucky to have state public defenders working with me in that endeavor and our entire staff, and I couldn't be more proud, as Ms. Moriarty says about our staff in the 4th District. We need to work together. At this point, it has become divisive. The folks who've written say I'm to blame or you're to blame. Ultimately, we have to take our own and we recognize for what our responsibilities and our mistakes are. I'll own up to mine any day. Always will. But ultimately, the idea of throwing in the, gender bias and this somehow timing is all about going after Ms. Moriarty is simply, utterly untrue.
Thank you, Mr. Ward. Ms. Moriarty, this is Board Chair Braun. I have a quick question for you. In your September 23rd letter to this board, you reference that you've made a number of mistakes and that you've learned from them, and yet it hasn't come to my attention what, if any, of those mistakes that you've ever identified or talked about. And I would like to ask you, what mistakes have you made through this process, and what have you learned?
I think in this is not just this process. It goes back several years, actually. And I recall I told you, and I shared this with the Personnel Committee this morning, that I had told you that Mr. Ward had engaged in inappropriate behavior towards me for a while. I shared with the Personnel Committee that when Mr. Kyer reached out to me about his reappointment, Mr. Ward's reappointment, I didn't want to participate in that because I feared retaliation from Mr. Ward, and I didn't think it would make a difference. I think one of the mistakes I made was as our relationship deteriorated, I essentially kept my head down and tried to run this office as best that I could. In other words, all of I had told you that Mr. Ward had lied to me, that there were things that had happened, but I made the mistake of keeping my head down and hoping that he would just not, that I could just run this office as best as I could without having much contact with him. Because that had become so negative and divisive and frankly demoralizing to me. And I told you that, how tough it was to be in this role without, not only without support, but while being lied to and other behaviors I described. And I should have figured out how to communicate that to more board members. Board member Lee, I hear you saying, why didn't I talk to you? And why didn't I talk to other board members about his behavior? Why didn't I try to figure out how to work better with him? I guess it's a tough thing when somebody is your supervisor and doing the things that he has done to me the last several years. But I think that I needed to figure out how to make something out of that relationship because I fear that it hurt our office, that retaliation has hurt our office. And that had I done a better job of trying to figure out some way to work with him, that wouldn't be the case. And so I have thought a lot about that, and what I could have done to try to work with him, because I just put my head down and I tried to do the best I could to run this office, hoping that he would just stay away. And that wasn't helpful to this office. It wasn't helpful to this office, probably in a number of ways. And so I regret that I didn't try to figure out how to make that work in some way.
Thank you. Any other board members who have not had a chance to speak in debate to the motion?
This is Board Member Harris. Can we call the question?
Thank you, Board Member Harris. There's a motion to call the question. I think we previously took a vote to allow for public testimony.
Okay.
And I think that we would not be able to dispense with the vote without doing that as we have suggested.
I agree. I detract. I take that back.
Thank you very much.
This is Board Member Meyer, and I just want to respond to Board Member Darris. I'd like to talk more about the statute because I'm a new member on the board as well, and when I looked at the statute, and we had a previous board discussion about it, 611.26, I think it's important that we know how we are to do business, and we just want to be sure that I think it's a really good point that we have a process that's that follows the law. It's really critical, and I know that you started out with your comments talking about I should put my video on. Here we go. There.
Well, then I'll put my video on too, Justice Meyer.
I just had it off, but in my version, I can only, there you are. I can only see the person talking. Hi. So when I read the statute, I think this question of public comment is really important because when I read the statute, and I thought this is how we had interpreted it as a board, but maybe we should have a further discussion about it. I read it that when there's a process we go through, and that the language talks about when appointing a chief, here is what you do. You quoted from the statute that we increase the membership with ad hoc committee members, that we seek recommendations from the public, the local bar association, and the judges. And that's clear to me, but it's not clear to me that that process applies when deciding whether to extend a contract for another 4 years. So,
yeah, Justice Myers. Chair Braun, am I recognized? Chair Braun?
I'm sorry. Thank you. You're recognized to respond to Justice Meyer. Yes.
Yeah, I look at the statute and I think about the legislative intent, and if you can see how thoroughly identified the public is. It's one of the only entities statutorily where it's identified multiple times in terms of public input. I don't think that our process for reappointment should veer too far away from how the statute is constructed. So the statute contemplates public input, and it actually contemplates it first and foremost. It contemplates it repeatedly throughout the reading of the statute. And so to me, that seems as though that's the legislative intent. It's for the people who are most directly impacted by whoever that chief public defender of that district is going to be able to have some say. In fact, to be able to have some centralized say in that appointment. And in our case, since we created a policy for reappointment, I believe that it should have been critical for us to contemplate engendering community voice in the reappointment process as well. I don't think it would be fitting for us to veer too far away from the construct of the statute itself. Certainly, we wouldn't want to veer too far away from the legislative intent of appointing chief defenders over districts.
Well, I mean, the language is, I think, speaks for itself. And rather than, get into discussion about statutory construction, it just plainly says when appointing a chief. My point is that as I understand the work of this board, we've never sought public comment with respect to reappointment, because reappointment is typically I would say more under the umbrella of a personnel decision, because the information that informs a reappointment is not all, there's a lot of it that's private. But we didn't solicit public comment, and we did receive public comment here, but I don't know how it was solicited. So it's hard for me to know what weight to give it, because it was clearly solicited by someone, because language is strikingly similar in most of the emails. In fact, it's identical in many of them. So if someone solicited it, I don't know whom, it would just be helpful if we agree as a board that we should have public comment. We really haven't. We haven't solicited as a board public comment. Somebody solicited public comment. And I'm not discounting it, but I'm also suggesting that it's difficult for me to say the public supports Mary Moriarty, because I don't really know how these remarks were solicited. The obvious ones, I guess I just don't know. And so, typically when a government agency solicits public comment, I think there's some general call for it, right? And I don't know what we've done in the past. We still see positions how we solicit it, but if it's so relevant to you, maybe it doesn't matter on the vote. But it strikes me that we should clarify that. Whether we haven't followed the correct process. And I would like more clarification on how this public comment was solicited. That would be helpful to me.
Madam Chair?
Yes,
This is Herb Crone.
one moment. Yes, thank you, Board Member Kroon.
Ms. Moriarty might know where the public comment came from. I looked at her private Facebook page, and in her private Facebook page, she asked people to send emails to us. And she said, if you want to do so, please contact me privately, and she gave them her email address. So I think that is probably where the supporters came from, is from her solicitation for letters of recommendation.
Thank you, Mr. Kroon. The chair would note that public comment will be welcome if indeed, depending on what happens today, if the motion that is before the court before the assembly is adopted, public comment will be sought prior to any reappointment decision in the 4th District. And obviously, if the motion before the assembly is not accepted or adopted, that would be a moot point. I would note that this board has received attorney advice from the Attorney General's office that our policy with respect to reappointment, as set forth in our procedures, is defensible within the statute and is proper to proceed under. And I would ask that we continue. If anybody has more to say at this moment on the issue before the board, the pending motion, I would invite that discussion, and otherwise, if not, we would like to move to the public comment portion.
Board Chair Braun, this is Board Member Dan Lee.
Thank you.
If I may be recognized.
The chair recognizes you, Mr. Lee.
As recently as yesterday, I and another board member who can choose or not choose to identify themselves pursuant to the attorney-client privilege conversation that we had as recently as yesterday with the Attorney General's office on the legality of the policies and procedures that we've undertaken in this process were defensible.
Thank you very much.
Chair Ron, this is Eli Darris. I know we want to move on so that we can open up for public comment. I just want to try to button hook this conversation, especially since the initial question was referred to me.
Sure.
I was actually also on the call with the Deputy Attorney General and also, I believe, the Solicitor General and Dan Lee as well, based off of a few questions that I had regarding the legality of the process that we were going down. And the opinion was that it was defensible. Part of my other question was whether or not it was advisable. And to your point, Justice Myers, I think that that's a conversation that we probably should have outside of this particular meeting and perhaps look to see whether or not our process is in as close alignment as it should be or could be with the statutory process for initially appointing a chief public defender, because the people who are members of that district, whether our process is appointment or reappointment, they still are going to have a chief. And so they still should have some level of say in that. But I believe that that's a discussion that we should have perhaps in a breakout sometime in the near future.
Thank you very much, Mr. Darris. Is there any further debate on the motion before the board? Hearing none, I would note that the board previously voted earlier in this meeting to allow for 60 minutes to hear public testimony. The chair would ask each of the members of the public that have emailed to the email that I provided, each of you wishing to speak, that you please limit your remarks as much as possible to approximately 2 minutes. To please identify yourself, spelling your last name, and identify what organization, if any, you are a member of. And to the extent possible, so that we may make the most of the 60 minutes, that you try not to repeat what the previous testimony has been prior to you. I would call on the Chief Administrator to call on the public as they have requested through the email process.
Madam Chair, thank you. We're taking these in the order that they came in. So the first name on the list is Bob Kolstad. Mr. Kolstad?
Am I unmuted? Can you hear me? Oops.
We can hear you.
Okay, thank you. My name is Bob Kolstad. I'm one of the union stewards for the lawyers in the Hennepin County Public Defender's Office. I sent you all a letter about a month ago or so, I believe. And I just wanted to, I don't want to take up a lot of time. I think there are voices that are more important than mine that need to be heard since I've already been heard. But I'd like to clarify that I did listen in on the meeting this morning. I've been listening to everything that was said here today at this meeting. And I want to make sure that you understand, or that you know, that after hearing all of that, that my opinion on whether Mary Moriarty should be reappointed to the chief position in the 4th Judicial District has not changed. In fact, I would say that after hearing from her and hearing from everyone else, that I'm even more in favor of her reappointment than I was at the time I wrote the letter. The second thing I would like to say is that there was some discussion about the solicitation of commentary by the public and where that came from. I wanted to make it clear to you that the commentary that came from the staff of the Hennepin County Public Defender's Office came due to organization by the people who work in that office. It had nothing to do with any solicitation by Mary Moriarty. We started to organize in support of her as our chief while she was on her suspension. I think probably the administrators are probably aware of that part of the organization. As far as the letters from the office, those were organized by the people who work in the office, and Mary Moriarty had nothing to do with that. I would also say that we are responsible for organizing many of the letters that came from other organizations. I can't list them all for you, but that we did also work outside of our office to get solicitation in favor of, or actually just to get input about the reappointment of Mary Moriarty. I was surprised to hear that it was all favorable because, well, you know, we didn't ask for just favorable commentary. We asked for commentary from anyone, regardless whether it was positive or negative. And so I don't want the board to have the impression that the commentary that you received here in favor of Ms. Moriarty's reappointment was all solicited by her, because I don't believe that it was. And in fact, I know that it wasn't. And that's all I have to say, and thank you.
Thank you very much.
Madam Chair, the next person is Corey Fleck.
Thank you. The chair recognizes Mr. Fleck.
All right. Next one is Darcy Sherman.
Thank you. The chair recognizes Ms. Sherman.
All right. Hopefully folks are hearing me. Jesse Dawn.
Chair recognizes Jesse Dawn.
I would like to note, as a member of the public, that I believe that people need to be informed that when they're called, they need to push *6 so they will be unmuted. Otherwise, just putting mute on their phone will not assist in that capacity.
I'm the first person that was called, and I didn't know that.
So, if we could go back maybe to the previous names before mine. My name is Jesse Dong, and then I will go back when it is my turn. I greatly appreciate it.
Thank you very much.
All right, Madam Chair, Corey Fleck.
Yeah, hi. Can everyone hear me now? Sorry.
Yep.
Okay. My name is Corey Fleck. It's spelled F-L-E-C-K. I have been a resident in Hennepin County for over 5 years now, and I'm planning on staying here for a very long time. I know that a lot of the board members here are not from Hennepin County, and so I just want to start by reminding everyone here that the job of the Hennepin County Public Defender, as I see it, is to take care of my friends, my neighbors, my community members, and I ask that as you're making this decision, you don't forget about that. I will admit that before this, I was following this and have written about Mary Moriarty in the past. So I do kind of find the implication that we could only know through her private Facebook page somewhat offensive, and should maybe have people reconsider how much you are publicly facing, because there are activist community members that are organizing people to help support, because we want to show that support. And so I do find it somewhat offensive, the implication that that's the only way I could have known to to have spoken here. The meeting with the Personnel Committee, even when I was, starting a defense, has been very disappointing and very shocking. And it paints a picture of people who are far more worried about their own power and their own personal feelings than the well-being of the clients that you're supposed to represent. The picture is really hard to pin down because it has felt incoherent at times what is actually being complained about. There's been these 2 anonymous complaints that were talked about and introduced, but with no context that add nothing to this discussion. There have been discussions about her appeal with or her ability to work with justice partners, which has been demonstrated in the fact that the sheriff and the police department chief wrote in. And it's felt like at every stage the board has, at least the Personnel Committee, has made decisions before and decided to pick and choose evidence that will help to point towards not reappointing and ignoring everything about the community support all of the people in support of this kind of argument. You want a public defender who will argue for the disparities in pay. You want people to be represented by someone that is high enough quality and the ability to retain that. That should be an issue across the state. And in fact, it's documented that Bill Ward has brought that up in the past. And so frankly, to find that as a reason to not reappoint someone is also somewhat offensive. The fact that it is moving around makes it hard to address any particular claim. And so you can talk about all of these different things, but it seems really apparent to, I think, anyone that's listening that's not in this board what's actually happening here, which is you say that you want a public defender who's going to advocate for racial justice, but you don't want them to ruffle any feathers. You say you want a public defender who will advocate for the people in their office, but not if they're being mistreated. You want them to spare your feelings. And the truth is, when there is this racial injustice, your feelings don't get to be spared. That's not what this job is about, and you can't advocate in that way without ruffling some feathers. Bill Ward said here in this meeting that his job is to protect the board. And frankly, again, I take offense to that, because the job of public defenders is not to the board. It is not to maintain your power. It is to protect the people who are disadvantaged in society. And I want to end by saying that I've seen a lot of defensive reactions from the board in this accusation of racial injustice, and a lot of pointing at other directions. And when people with power are often told that they are not using that power to fight injustice hard enough, they often respond with this defensiveness. They look for other places to blame or other people to put it on. And so it's my deep hope that whatever you end up doing, that moving forward, you will all take a second to stop your defensive reactions to these calls for racial justice, that you will start asking more fundamentally why so many people don't trust the justice system. And that includes public defenders. Why is it so hard for community members to feel they are part of this system? And why did they finally feel comfortable marching with Mary? Why has it taken so long to repair that relationship? And I hope you look at the role that you are playing in that. Words are different from actions. You can say that you advocate for racial justice and that all of you on the board do that, and you might be offended when we tell you that you aren't. But if you don't reappoint Mary Moriarty, then your actions aren't reflecting that. It's clear that all of these personal issues stem from the fact that she is fighting for systemic racism or fighting against it. And it's clear that you have come up with these interpersonal reasons to justify that. You can dismiss it or talk away whatever you want, whatever will help you feel like maybe you aren't advocating or increasing the racial disparities in our legal system. But when you're results-oriented, when you look at the outcomes of Hennepin County and you throw that out, I think it's pretty clear what you're doing. I yield my time.
Thank you. Darcy Sherman?
Hi, can you hear me?
Yes, thank you. The chair recognizes you.
Thank you. I am an attorney in the Hennepin County Public Defender's Office. I am also the other steward representing the attorneys in our office, and I am deeply disturbed at the discussion today. I am very disappointed in what I'm hearing from the board right now, particularly the concerns from Justice Meyer that, we might feel that we're special and that would be some sort of concern. When we're talking about that pay disparity, I think it's essential to note that the median house price in Minneapolis is $305,000, which is more than twice the cost, the median house price in a number of the other cities where we have offices. Daycare is more expensive here. Transportation is considerably more expensive here, but our salaries are the same. And because of that, we wind up losing people, not to the private market, but to other government jobs. We have lost 3 attorneys who loved working in our office and loved representing our clients and who were phenomenal at it, to the Duluth city attorney's office because they're making way more money, they're working way less, and they're in a lower cost of living city. We have lost at least 5 lawyers to the ARS unit at Hennepin County, which was created to represent parents in CHIPS proceedings, because again, they are making way more money for less work. This is the problem we have. Issues of attrition are not, they are different in outstate, but they are statewide. And I am so frustrated that you do not understand the unique situation that we are in. Every office is different, every office is special, but our person felony lawyers all have 2 murders and have all had at least 2 murders for literally years, and that doesn't happen in other parts of the state. We are burning out at a horrifying rate. We did not get a reprieve during COVID like some of the other offices. We have been in court, and I have zero faith at this point that the board understands, because I think only one of you has ever even come to our office, understands the specifics of our challenges. And Mary has been advocating for us, and we are appreciative of that. And it's necessary to stop the bleeding people leaving this office because of the intense stress of our court calendars, paired with the economic strain of living in a high cost of living city. Thank you.
Thank you very much.
Madam Chair, we're back to Jesse Dong.
Thank you. The chair recognizes Mr. Stamm.
Thank you. My name is Jesse Dong. My last name is spelled D-O-N-G. I'm an assistant public defender in Hennepin County. I'm a resident of North Minneapolis, and I am the Minnesota Asian Pacific American Bar Association representative to the Hennepin County Bar Association. I would just like to highlight a few things. First, noting the comments that were solicited or provided to the State Board of Public Defense. In July of this year, I received an email from Bill Ward asking me to provide recommendations and comments to him. When I received that, I thought I would also just send it to the board as well. So I know that many of us did receive that email and felt as a result of that email from Bill that we should provide our thoughts to the board in considering this reappointment process. So I know that board member Kroon had been noted that Ms. Moriarty did post something on her Facebook page on August 27th, but I just wanted to note that a month prior, almost 2 months prior, some of us had received a solicitation from Bill Ward to also provide input into this process. I want to note that earlier in the Personnel Committee meeting, there was conversation about the reprimand that Ms. Moriarty received and that they wanted to bring it back to that. I was reading through the reprimand again today, and I noticed that it highlighted 3 parts: the unauthorized comments that she had made, the number of justice partners who have fractured relationships and are non-collaborative, and her social media comments. At no point in those 3 outlined behaviors did it mention anything about her relationship with employees in this office or her ability to manage people within this office. It does note in that letter that it is based on the following concerns, not meant to be exclusive concerning behaviors, but I do want to note that her relationship with her employees was not noted in that section. In the parts that followed, where there were expectations of what she would do going forward, the only mention about an employee relationship was to not retaliate against any employee or third-party member. That is the only mention in the entire reprimand that I saw that was talking about her relationship with people that she directly manages or are in our office. I also recognize that, again, during the Personnel Committee meeting, there was a large conversation about Hennepin County and how it's trying to be seen as special. I do not believe that our office is special compared to other offices, and I do second what Ms. Sherman said about the fact that we do have distinct difficulties here. I am a young person, I am single, and I only have to take care of myself. And I'm privileged enough that the money that I make isn't sufficient for me. But I am very much aware that there are many people here who are supporting others, who have family members, who have other financial considerations. And in Hennepin County, the amount of money we make is very difficult for a lot of people to continue being public defenders. And this pay disparity is a significant impact on our office. I've had many friends leave our office because of this. And I think it would make sense that Ms. Moriarty would want to bring attention to this. And the current system of the State Board of Public Defense perpetuates this disparity and this discrepancy. And what has been made apparent to me, and maybe this is incorrect, but what has been made apparent to me is that this is not a huge concern for the State Board of Public Defense. And I understand that there used to be a system that did not have this pay discrepancy. And I understand that that was in the past. I understand that Justice Meyer had asked us to not focus on issues of the past. But I do believe that because there was a past way that addressed this issue, and because this issue is so important to us, it is something that we do come back to. I do not wish ill on any other part of the State Board of Public Defense or other public defenders in the state, but I just want to note that is a huge concern to us, and it is something that we do want to highlight, and we have been appreciative of Mary highlighting. Thank you. I yield my time.
Thank you, Mr. Dong. I appreciate it. And Mr. Carr, could you please call the remaining names?
Michelle Gross.
Chair recognizes Michelle Gross.
Thank you. Are you able to hear me?
Yes, thank you.
Thank you. My name is Michelle Gross, and I'm president of the organization Communities United Against Police Brutality. We are an all-volunteer organization that's been in existence for 20 years. I have personally lived in Hennepin County for 28 years. Our organization is one of the organizations that did solicit comments from the community because we feel that it is important for the community to have input into this process. We did not write a script or give people any language to use, but we also wrote a letter representing our organization. And I note with interest that the letter that we wrote, which we sent in quite a while ago, it was not included in, and then I also resent it a second time recently, was not included in the packet of materials for this meeting, which makes me concerned that our letter and the many others, it was noted earlier, 175 letters, are not going to be included in the official record. And so I would, insist that that happen. It became apparent to me, I listened to the personnel meeting this morning. I've been following this matter closely. Our organization has worked closely with the Public Defender's Office for 2 decades. And in fact, we've appeared before the legislature soliciting additional funds to support the public defender system and that specific office. And so we have an interest in this matter and in this office and its functioning. We also represent a lot of people who use those services. And I can tell you from 20 years of going to court with these folks, watching this system, people used to refer to the public defenders as public pretenders. We don't hear that kind of language anymore in the office under Mary Moriarty. The quality of the services have improved vastly. They have people are dedicated and professional. We like the quality of what we see out of there. I've been nothing but impressed, and that was why we were so eager to write our letter. But I was very disheartened as I listened this morning to the personnel meeting because it seems, frankly, like a lot of pettiness, a lot of political reason, and it was really brought home to me the politics behind this effort to oust Miss Moriarty when I heard Justice Meyer say, and I quote, "Her battle against the state system has to be put down." And I was truly appalled by that statement. Put down almost as if you're talking about a dog or something. It was really, really appalling to me. And the thing about it is she has every obligation, not just right, but obligation to advocate for her staff members. Her staff members are being deeply underpaid. They're being underpaid compared to the cost of living in the state, but they're also being underpaid compared to their adversaries on the other side of the aisle, meaning the Hennepin County Prosecutor's Office. If Justice Myers is so concerned about everything being brought under the state umbrella, why haven't the prosecutor's offices been brought under that umbrella as well? I recognize the prosecutors are elected, but their staff members are not, and they could certainly be brought under that same umbrella and receive the same unjust treatment that Ms. Moriarty's staff are receiving at their pay levels. I go on to note that other members of the board have raised, gosh, where did we get these letters from? Maybe Ms. Moriarty is asking for them. She never asked our organization to support her. We came forward ourselves on our own volition because we feel that the work she has done is very important, has greatly elevated the quality of the office, as I stated earlier. She never asked us for any support or solicitation of any type whatsoever. We are doing this on our own, and we're an all-volunteer organization. We have no paid staff, so for us to make those efforts is significant because all of us are volunteers, myself included. This nonsense about she doesn't play well with others, I'm sorry, I recognize my time is close to end, but I'm going to be done in a moment. I recognize that, or I should say that this kind of statement of, quote, she doesn't play well with others, I mean, that's paraphrasing, of course. So what? She shouldn't be playing well with others. She shouldn't tolerate the Brady violations of the Hennepin County prosecutor's office. She shouldn't be tolerating the injustices of requiring defendants who are represented by public defense to come to court in person to have their hearings when other people can have telephone hearings. She shouldn't be tolerating these things. The Hennepin County prosecutor routinely goes to the media to complain about things. I think we have to give equal standing to the Hennepin County Chief Public Defender. And I urge you to reappoint Ms. Moriarty, who has done an outstanding job. And I'm sorry your feelings were hurt and whatever you feel has happened. But listen, the importance is how that office runs. The community demands that you reappoint her. Thank you.
Thank you very much.
Madam Chair, Claire Deagle.
The chair recognizes Claire Deagle.
Jared Mollenkoff.
The chair recognizes Mr. Mollenkoff.
Hello, can you hear me? Hi, this is Jared Mollenkoff. I am an attorney at the Hennepin County Public Defender's Office, where I have been for the last year. Prior to that, I was a public defender in Nashville for 8 years. I have commented in writing to the board. I have also contacted you in my role with the Minnesota Freedom Fund, an organization that has worked with the Hennepin County Public Defender's Office and has collaborated with Mary on a number of issues that affect both the clients that we represent in both capacities. And I'm calling in not to reiterate the arguments that I've already made, but to just point out a couple things. I think that it's a concern to me that it appears that the ad hoc members will not be allowed to vote on this reappointment. That does not appear to be appropriate under the statute, and maybe even if the AG's office believes that it is defensible, I would ask if it's right. If the representatives from Hennepin County that vote on initial appointment, whether it's just to our county not to allow them to vote on the question of reappointment, and I would ask that they be permitted to do so. I also want to just talk a little bit about what my experience working with Mary has been like. The pandemic and the way that it has affected our caseload and quality of life being a public defender has been extremely difficult. On the person felony team at the public defender's office, I know that people feel extremely overworked, feel as though the system has not kept us safe during this pandemic. And when I came in to start my first jury trial here in Minneapolis during the pandemic, I ran into Mary at the first floor of the government center. And sort of in passing, went to, just mention how stressed out I was, how concerned I was about starting this trial. And Mary set down what she was doing, went with me to an empty office space, and went over my entire opening statement with me. This is a woman who runs an office of 120 lawyers, who had no expectation that her Monday morning was going to be taken up with me delivering an opening statement. And she sat there for an hour with me while I rehearsed my opening statement, gave me feedback. And then at the end of that week, when what was a really difficult loss in court, she reached out to see if there was anything that I needed. She stood alongside me. She is the kind of leader that our office needs right now. The idea that in the middle of this pandemic, we could go through the uncertainty of having our boss removed, a boss that I came to this office to work for, is, on a deeply personal level, extremely upsetting. And it would diminish the work that we do, and it would be extremely difficult for all of us. Thank you for listening to my comments.
I appreciate it. Thank you.
Madam Chair, Lindsay Van Beek.
The chair recognizes Ms. Van Beek.
Can you hear me?
Yes, thank you.
Hi, this is Lindsay Van Beek. I'm an attorney with the Hennepin Public Defender's Office. Prior to working at the Hennepin Public Defender's Office, I was a public defender in Greater Minnesota, particularly Bemidji and Park Rapids. So I am very familiar with the conversations that happen in Greater Minnesota about Hennepin and about pay parity across the state. Today, I heard board members dismissing the concerns public defenders all over the state have about being able to provide for their families. I heard board members dismissing the overwhelming support that Ms. Moriarty has received from her office. And I also heard board members complain about how their egos were hurt because Mary or Ms. Moriarty dared criticize their decisions. Mr. Ward said in his statement that his job was to protect the board. But quite frankly, it shouldn't be. You, as the board, are not the most important people here. Our clients are. The people that we represent every day, the community, are the people that we fight for, go to work for, get underpaid for, and care about. And Ms. Moriarty has been a huge part of that. When I was listening to the personnel meeting this morning, one board member was very passionate about the fact, and Mr. Ward mentioned this as well, that this has nothing to do with Ms. Moriarty's comments on racial justice. And I just want to say that that is insanely ignorant of our job. You are ignoring the fact that the vast majority of our clients in Hennepin County and in the counties that I've worked in Greater Minnesota are people of color. And that the attorneys who represent them are chronically underpaid and overworked, and that affects our clients. In fact, the lack of pay parity has led directly to attorneys of color leaving this office and the offices that I previously worked in. Racial justice is intertwined throughout public defense, no matter how much people would like to ignore it and how much of an inconvenient truth that is for you. In regards to how Ms. Moriarty treats her staff, I will tell the board that I have worked for chiefs who are universally disliked. People in their offices hated them and avoided them when they saw them in the office. That is not the case with Ms. Moriarty. She is well liked, she is well respected, and it is that respect and like is well deserved. The fact that we are even having this conversation about whether or not she gets reappointed is a slap in the face to every public defender who sees the commitment and the passion that Mary has for advocating for us. We see how you see us, and we don't like it. Thank you.
Thank you.
Madam Chair, Claire Deagle tried to get on and couldn't be heard. Claire, are you there? Okay. Try to come. Kate Hunzel?
Chair recognizes you to speak.
Madam Chair. Madam Chair, if you can send a reminder to everyone to press star 6 to speak.
Yeah.
Thank you.
Hello?
Yes, ma'am, please proceed.
Thank you so much. I kept getting notifications that I was unmuted, but I don't know what's going on. My name is Claire Diegel, C-L-A-R-E, last name D-I-E-G-E-L. I'm a proud former public defender under Ms. Moriarty. I'm currently a staff attorney at the ACLU of Minnesota, but all the views I'm about to express here are solely my own. I'm not speaking in that capacity at all. I just wanted to point out that the policy promulgated by the board has 5 specific goals, and I won't waste my time going through those goals. The board members are all very clearly aware of them. And I just think that the National Center for Court finding that Mary's public defenders were more successful than private counsel in terms of effectiveness of case processing practices, and, quote, as successful as private counsel in achieving favorable outcomes for clients, means that she has exceeded every single one of those goals. It is nonsensical to say that Mary is not a collaborative justice partner when she is getting outcomes for her clients like that. Those statements from the National Center for State Courts shows that she is an effective advocate inside and outside of the courtroom and within her own office training staff. That should be the end of the story. And it was very, very upsetting and disheartening to hear the Personnel Committee comments this morning. One board member saying that Hennepin County public defenders thought they were special. The comments about Ms. Moriarty being insubordinate for talking about pay disparity, those are offensive. The Board of Public Defense is not in jeopardy. The Board of Public Defense is not in jeopardy. Ms. Moriarty going to the county and asking questions does not mean the Board of Public Defense is going to implode. I just really urge the board to look at the objective facts here, to not consider whether or not Mr. Freeman or anyone else may, quote, trust Ms. Moriarty. Those things don't matter. What matters is that the people of Hennepin County are competently represented in a system that is set up to oppress them. So for those reasons, I would ask every board member, even those who have already said they're not going to do it, to reconsider and vote in favor of Ms. Moriarty. Thank you.
Thank you.
Madam Chair, Kathleen Cole.
The chair recognizes Kathleen Cole.
Hi, can you hear me?
Yes, thank you.
Thank you. My name is Kathleen Cole. Cole is spelled C-O-L-E. I'm speaking as a resident of Hennepin County and also as an organizer with We Call Freeman. First, I'd like to note that this is no real public comment period. The public was not made aware of the opportunity to speak in support of Mary Moriarty with adequate notice. And throughout this process, Hennepin County residents have been purposefully excluded. Our organization, Recall Freeman, we solicited public comment. We're responsible for many of the letters you received. And we organized in support of Mary Moriarty of our own accord and without her solicitation to do so. We wrote a template letter for people who wanted to write in, but didn't know how to make a public comment. Because we wanted to help them, people who would have been too intimidated to make a comment on their own. We organized on her behalf because we see her as an ally in our work of decarcerating Minnesota. I've listened to the board proceedings today, and I am truly disgusted with what I have heard. The objections to Mary Moriarty's appointment had nothing to do with her service to the people of Hennepin County. What I heard without exception was criticism based on Moriarty's advocacy. It seems very clear that the problems those board members have with Ms. Moriarty have to do with the challenges that she has made to their power and status. It seems more significant to the board that they protect their own oversight of a statewide system than that poor folks get the excellent protection that Ms. Moriarty provides them. That you care more about your board's reputation and power than you do for the amazing work that she does to protect the most vulnerable defendants in our system speaks loudly and poorly for all of you voting against her reappointment. You should be ashamed of yourselves. And I speak for many in the community when I let you know that we're ashamed of what you're doing. We're ashamed of you. You don't speak for Hennepin County. Thank you.
Madam Chair, Amanda Broadhag.
Thank you. The chair recognizes Amanda Broadhag.
Max Friedman.
Chair recognizes Max Friedman.
Hi, this is Amanda Broadhag.
Oh.
Thank you. The chair recognizes you.
My name is Max Friedman. Friedman is spelled F-R-I-E-D-M-A-N. I am speaking as a private citizen. I live in South Minneapolis, 3132 Cedar Avenue South. You can look me up. I just want to say, I'm disgusted with the board that this is even in consideration. I hear complaints about professionalism. I don't give a fuck about professionalism. The only professionalism I care about are Moriarty's success as a public defender defending the public. She has an exemplary record of doing her job, and the fact that she is up for this is mind-boggling. I've just been pacing my room angry about this and angry at you. Here in Minneapolis and across this entire country, our trust in the public system, our trust in public defense, our trust in the justice system is at an all-time low, and we have one exemplary person doing a good job helping the people, and you're going to get rid of her over what? Because she was mean to you? Fuck you. Mr. Ward, if you and me were in the same room right now, I would spit in your mouth, and I'm going to get tested for COVID later today.
Your comments are out of order. Mr. Kyer?
Madam Chair, I think Kate Hunsel is back on. She tried before. Kate?
Hi, this is Amanda Broadhag. Can you hear me?
Okay. All right.
Thank you. Yes, please proceed.
My name is Amanda Broadhag. Broadhag is spelled B-R-O-D-H-A-G. I am an assistant public defender in Hennepin County. When Ms. Moriarty came back from her reprimand, she immediately joined the discussions for COVID-19 precautions in the courtroom setting. This came at a time where the entire nation's court system was shut down due to safety concerns for attorneys and clients being in courtrooms. As soon as she was allowed back online, this office breathed a sigh of relief. She came to speak on behalf of our clients' safety concerns and her staff's safety concerns. She mobilized quickly to provide one voice and push back when the court was asking us to work in unsafe conditions and providing a double standard for our clients, us, versus the individuals who are prosecuting our clients. Additionally, as a public defender, I believe strongly it's my duty to agitate other members in the criminal system. Late Representative Lewis thanks Ms. Moriarty for getting in the way. Getting in the way is an important tenet when the remaining members of the American criminal system are not willing to remember our clients as humans and that they need equal treatment under the law, as the Constitution clearly states. Her demonstrated leadership inspires those in her office who overwhelmingly support her, as you've only heard a fraction of that support today. Those who have been trained by her walk into the courtroom more prepared with the tools to be excellent advocates. Mary, to you personally, it's an honor to be your employee. You have certainly not let me down. You are a strong example of the public defender I strive every day to be. To the board members, I strongly recommend you either reconsider your vote or you vote as you are planning to reappoint her. Thank you.
Thank you. And I would remind board members and others to please make sure that your screens are on mute when you are not speaking. Thank you. Mr. Kyer?
Yes, Madam Chair, Latanya Reeves.
The chair recognizes Makanya Reeves.
Good afternoon. Can you hear me?
Yes, thank you.
Good afternoon, everyone. I have some comments I would like to make, and this is short notice. I wasn't prepared to speak. But my name is Latanya Reeves. I'm a Hennepin County Probation Officer. I'm the president of SB Local 552 and the current president of the Hennepin County Policy Committee and various other roles. And in that work, we have been looking at racial disparity and justice. I would like to commend Mary Moriarty for the work that she has done in racial equality and justice. I've attended her trainings, read some of her work, and I just appreciate the advocacy. That is something that we need right now at this moment in time of civil unrest in Minneapolis and across this nation. She is well respected by those that I've spoken with in many areas. I am a researcher and currently obtaining my PhD in criminal justice. She is well known in various areas of this field. And as a stakeholder, I want to just let her know that I appreciate her hard work. I was not privy to the previous committee from this morning. I've been following this case on the news, so I'm limited in terms of some of the things that I'm hearing and in regard to knowing what you're speaking of. But in terms of her herself, I want to thank you for your service. For Hennepin County, I want to thank you for advocating for Black people in this community. I want to thank you for being that voice. As John Lewis says, good trouble, necessary trouble. In the words of him, in terms of racial justice, equality, we need someone that will speak up in regards to this issue. We need not be silenced in this. It's a difficult conversation, that is for sure. And everyone may not want to hear what she's speaking of, but it is necessary. It is absolutely necessary. I attended that board meeting that you guys are speaking of last year. I was very pleasantly surprised by the advocacy she gave her staff in that meeting. I attend all board meetings as part of my role, but I want to thank her for that as well. I'm not a public defender, but I work with them every day with my clients, and I'm sure they appreciated her advocacy, but I appreciate her standing up in front of that board and saying what needs to be said in regards to racial equality, the number of Black public defenders in the office, and why we don't have them. We have to start speaking up, and we can't silence someone in our community who chooses to do so. We need people that look like Mary Moriarty speaking up for us. We need white people speaking up for racial inequality and justice. We have to have that to get anywhere with this conversation. So I want to thank her for her advocacy, and also just wanted to comment about the performance review. Hearing that she hasn't had one in 6 years, it's on the responsibility of her supervisors to have given her the feedback as to what they thought was wrong. To come back now and say we're not going to reappoint you because you had issues with your staff and other issues and you didn't put them in a performance review speaks to the supervisors that she is working with, because that should not have happened. And if you're going to look at this in terms of reappointment, that should be your number one concern. If we're talking about job responsibilities and how someone interacts with their staff as a chief, then you must have told her in a performance review before you could then come back and advocate and say, we're not going to reappoint her. So as a union person, that's the number one mistake I'm hearing on this call. Most of these comments I'm saying are from my personal experience, so I want to make that very clear. But again, please reconsider your opinion to not reappoint her, because again, we need her advocacy in this community. It may not be what you want to hear, but it's needed, and it has to happen. I thank you for allowing me the time to speak. You guys have a wonderful afternoon.
Thank you, ma'am.
Madam Chair, Kathleen Cole.
The chair recognizes Kathleen Cole.
Okay. Madam Chair, Perry L. Moriarty, Associate Professor at the University of Minnesota.
Thank you. The chair recognizes Mary Moriarty.
Hello, can you hear me?
Yes, thank you.
Okay, I'd like to start by saying that I'm not related to Mary Moriarty, and my name is spelled differently. It is Moriarty. I'm an associate professor at the University of Minnesota. I teach criminal law, juvenile justice. I co-direct our juvenile justice clinic. I have a background in public defense. I'm also heavily engaged in policy reform in Minnesota. I've served on several state commissions, including with Mr. Ward. I've been heavily involved in legislation affecting the people who we should be talking about today, the clients of this office. And finally, I mentioned that I am also on the board of a local foundation called Midnight Foundation. And I mention that because we are strategically engaged right now in racial equity work in Minneapolis and in Hennepin County. That is brand new to us. And one of the chief reasons we've undertaken this work is because we do have partners like Ms. Moriarty in places of authority that we had hoped to work with. I've known Mary Moriarty for a few years as my colleague at the law school. And increasingly, I've gotten to know her more intimately over the last year, in part because so many of my former students work for her office, and my current students are clerks at her office. And I have students who hope to go there in the future. And I will say that absolutely without fail, my students describe her as one of the chief reasons they want to be a public defender in Hennepin County. They go there because they know they will be well trained, because they will have the support of their supervisors to be client-centered advocates to fulfill the goals that this board has set out as its primary goals, and because they will be engaged in rigorous advocacy of the type that only a few offices in this country offer. 3 of the 5 individuals who were scheduled to start at this office, at Mary's office, in early September, were my students. And all three of them had spent the better part of this summer. They got offers last February, preparing to go work at this office. They took the July bar exam based on a commitment from the office to bring them aboard and hire them. They turned down other offers. They were counting on employment at this office. And to hear now that her efforts to secure employment for them when there was an overarching threat that their offers would be rescinded is somehow insubordinate is utterly mind-boggling to me. They would be without health insurance to some extent, without secure employment right now. This is a commitment that I believe the state board had made by allowing the Hennepin County Public Defender's Office to extend offers and have people accept offers months in advance. And I mention all of this because the overarching theme I'm hearing right now is that, I think I'm echoing what I've heard from others today, that Mary may not be reappointed because she has made decisions on behalf of her clients and on behalf of her staff in a way that doesn't feel professional enough or acceptable to the board. And candidly, that's staggering to me. The board has set out its mission quite clearly, and that mission is to serve the people of this state who must have appointed public defenders because they cannot afford private counsel. And that is the primary mission. And that we are now here today, whether we call it reappointment or appointment, and focused on interpersonal relationships between Mary and, I've never even heard the term justice partners before, but I guess I have now. And that is the reason that the clients of this office may no longer have a chief who has increased the caliber of this office in ways that, frankly, are nationally renowned at this point, is something that I never had expected to hear from the board. I won't belabor this except to say that I really hope the board can take a step back now and consider another way forward. You know, I know Mr. Ward, I know Ms. Moriarty, I know members of this board. And what I'm hearing today, and I'll say it goes beyond what feels like a nominal employment decision. It feels like something that is, in Ms. Moriarty's words, more than just about her. And I'm concerned that if the board moves forward swiftly today and votes against reappointment, that there will be done some irreparable damage, not just to the institution that is this board, and there are very fine people on this board. That is certain. I don't think anyone doubts that. But the broader question here is, you know, we are at a crisis point I don't think anyone denies that, in all sorts of different ways, locally and nationally, and particularly when it comes to those who are served by this office. And what this process feels like is something wholly immune and remote from the rawness and the real necessity that is having public servants that are beholden and accountable to our community. And I am deeply concerned, as someone that works in parallel with the public defender's office, that represents clients in the system, that sends students to this office who are emailing and texting me now saying, how can I stay there? How can I go work there if this is how this is going to play out? I really hope, I don't know if it's a motion or something procedural, that the board can take a step back and ask whether this is really worth it, whether this is really the direction that the board should go. I apologize for the emotion of these comments. I hadn't expected to make them. I hadn't expected to feel this emotional about it. But I echo what I think you're hearing from a lot of people, that this feels like something much more fundamental. And I would also ask procedurally that if it is true that Ms. Moriarty has not had performance reviews in 6 years, isn't there more that the board could do to work on, whether it's through mediation or something else, internal relationships between Ms. Moriarty and the board and Ms. Moriarty and Mr. Ward? I think it's worth at least considering. Thank you.
Thank you.
Madam Chair, is it Marecka Vertin, V-E-R-T-I-N?
Thank you. The chair recognizes Rector Burton.
Madam Chair, this is Board Member Harris. Before she speaks, I just want to bring to your attention, can you let us know when we will be voting? I'm going to have to leave the meeting at 3:10.
Thank you very much. My intention is that as we stated, the hour will be up at 3 o'clock for the public testimony, and then I would be happy to call the question if that is in order with the Assembly.
Okay, thank you so much.
Thank you.
Hi, this is Marecka Vertin.
Thank you. You're recognized. Please proceed.
I'm calling today as an employee of the Hennepin County Public Defender's Office. So I first just want to be a voice, another voice here today in the room, noting the breadth of Mary Moriarty's support across the ranks of our office at various levels. I'm a newer misdemeanor level attorney. Ms. Moriarty has welcomed me into the office. She's a large part of why I came to work at this office, and I already would not be the attorney I am today without her. And I just want to echo briefly, as stated by Ms. Broadhag, I believe she put that very well, just the feeling in my bones as a staff member of this office of learning of Ms. Moriarty's return from her suspension in the middle of this pandemic, how as soon as that occurred, I wasn't scared to come to work as soon as she was back at the helm. I also just want to add briefly, as I think maybe every caller has done before me, as to the comment about how this community support has been solicited in my endeavors outside of work. I certainly know and understand that Ms. Moriarty has deep support within the community from various different organizations, groups, people, that support is deep. That our office has support within the community in part because of her leadership. And of course that the community at various levels is capable of and has organized itself to weigh in on this very important issue in support of her reappointment to our office. And that matters. Those voices matter. And lastly, I just want to make an ask as an employee of the state board. You know, I've heard in this meeting that board members want to make this decision and some plan to make a decision on reappointment on the basis of their evaluation of how Ms. Moriarty has worked with the state board. And I don't want to weigh in on the substance of that evaluation. What I want to ask is, you know, I've heard something in this meeting such as, you know, usually chiefs work with Kevin and Bill. I don't want to weigh in on that. I guess what what my ask is basically to make what for those of you in that position, what might be a hard decision, which is to prioritize our clients, to prioritize the voice of the local community. A board member has stated that this reappointment isn't about Ms. Moriarty's excellent advocacy. It isn't about her success in leading this office, as is well documented. And I think and what some other callers are asking is that you make it about that. Thank you.
Thank you. We'll take one more caller, please.
Madam Chair, actually, Nakima Levy-Armstrong, and then if we can, I think Kate Hensel was back on, and she was in before, so, Ms. Armstrong?
Thank you.
Hello?
Yes, the chair recognizes you, Ms. Armstrong.
Thank you, Madam Chair, members of the committee. I'm Nakima Levy-Armstrong, a civil rights attorney, former law professor at St. Thomas, and former president of the Minneapolis NAACP. I'm also the founder of the Racial Justice Network, which is a grassroots multiracial organization that has been on the front lines of a lot of unfolding racial justice issues in the Twin Cities. So I'm calling to unequivocally state my support for Mary Moriarty, her advocacy, the connections she's been able to build in the community, and her effectiveness as the Chief Public Defender for Hennepin County. I first learned about Mary Moriarty actually from some of my law students who were in my civil rights clinic at St. Thomas while also interning for her office, and they would come back to class excited about Mary and telling me, you have to meet Mary Moriarty. She is excellent. She cares about racial justice. And this was years ago, before there was, the national conversation that we're having right now about these issues. So
Welcome to the audio conferencing center. Please enter a conference ID. After the tone, please record your name and then press pound. You're now joining the meeting.
Proportionality.
You've been muted. To unmute yourself, press *6.
Pulled over for a busted tail light might not be a big deal, for people in certain communities, but in places like North Minneapolis is definitely a big deal, because we know that being pulled over for a busted tail light can become deadly, as we saw in the case of Philando Castile. And so once Mary made us aware as the public of those issues, our organization essentially assembled a public forum to raise awareness and also to bring in stakeholders like folks from the Minneapolis Police Department, the ACLU, and we had Mary as one of our experts on the panel, along with Valerie Castile and several other stakeholders to talk about this issue. And after we raised public awareness about this, we were able to engage Chief Arredondo for nearly a year as we pressed him to consider a moratorium on equipment violation traffic stops, because we know it's often an economic issue. And it is also a tool for police officers to engage in searches, primarily of African American motorists, even though, you know, we saw from the statistics they're actually less likely to even find contraband, you know, during those searches. And so through that process, the chief ultimately decided to have his officers no longer give people criminal citations if they have an equipment violation, but instead to give them a coupon to go to a local auto body shop to have their cars repaired. That type of systemic change, which from my perspective prevents people from entering the criminal justice system or going more deeply into the system and actually saving lives, would not have happened were it not for Mary Moriarty and her team of public defenders who are paying attention to these systemic issues. That type of insight and collaboration is extremely rare. Just from my own experience of working, you know, outside the system, challenging people within the system, and holding various positions. And so when you have a leader who is able to excite the staff, mobilize the staff, engage the community at a heightened level as well as stakeholders, you do what you need to do to hang on to that person. And when I'm listening, you know, to this conversation from earlier today and then this morning, it's really distressing because a lot of it, as other callers have said, is very petty. It sounds a lot like white male fragility at play in this situation. And I also feel that if Mary were not a woman, that she wouldn't be treated in the way that she's being treated right now. And I know from personal experience as an outspoken woman, how easy it is to become a target when you step on the wrong toes or the toes of people who are used to not ever being challenged for their behavior, their perspectives, etc. So I support Mary. I was also one of the people who encourage people to write emails and letters to you all, letting you know how they feel. And I think that it's astonishing that so many people in the midst of a pandemic, worrying about their own lives, took the time to write to you all in support of Mary Moriarty. I feel that that's unprecedented support in a situation like this. I hope that it signals to you all how important Mary is to this community, how important she is to our staff, as well as the clients that are served by her office and through her advocacy, who overwhelmingly are poor people of color. So thank you all for listening and giving me this opportunity to weigh in, and I just hope that you're willing to take all of this seriously. Thank you.
Thank you.
Madam Chair, we have, there are other people who have asked to testify. We have two people that we weren't able to or weren't able to unmute. The first one is Kate Hunsel.
Hello.
Kate?
Yes, this is Kate.
Thank you. The last two members of the public, if you could please confine your comments to just a minute or two as we have business to proceed with board members needing to leave. Thank you.
Absolutely. My name is Katie Hansel. That's Hansel. I'm an attorney at the Hennepin County Public Defender's Office, and I work on the person felony team. I absolutely support the reappointment of Mary Moriarty as our chief. I've worked on the person felony team here in Minneapolis for a little more than 2 years, and prior to that, I worked as a public defender in the South for 7 years. That's where I originally met Ms. Moriarty at a training program when I was a very new lawyer. Ms. Moriarty was an excellent trainer and mentor to me and other attorneys early in our careers, and she was a big part of why I came to the Hennepin County office 2 years ago, taking a pay cut to do so. I knew that there was someone running this office who was promoting client-centered representation and would support us as her employees to do the same thing. This job can be really, really hard. We work in what is designed to be an adversarial system. And there are a lot of systemic pressures to do things that aren't in our client's best interest and are not client-centered. I think having someone leading our office that always does support us in our advocacy and promotes our ability to represent our clients is really essential to keep being able to be dedicated to this job and giving our clients what they deserve, which should be the focus of what we do. This is especially true during COVID-19 over the past couple of months. And Mary Moriarty is absolutely that person. I've felt able to do this work to the best of my ability in furtherance of my clients' goals under her leadership. It has been really uncertain. It has been really chaotic over the past months, especially on the team that I work on, and having Ms. Moriarty leading our office made it possible to continue doing this job and advocating for my clients during the difficulties of practicing during COVID-19. Most of my clients are not white. They know the kind of racism and discrimination that this system meets out against them, and they deserve representatives that fight for them and that name those injustices that are absolutely based on race, and also examine their own role in these systems and our relationship to race and white supremacy. I am asking you on behalf of...
That's madness.
Thank you very much. I apologize for that.
Kathleen Cole?
No, Mr. Kyer, I'm sorry, but the public testimony portion has ended now. I would like...
We skipped over Ms. Cole earlier because she couldn't get in, but...
I understand, but there's a board member that has a time consideration, and I believe we've gone well past our 1 hour that we indicated for this portion of the discussion.
Madam Chair, may I be recognized? This is Board Member Whitmer.
Please.
I do not feel ready to take a vote. I feel, I mean, if we're telling me that we're not going to discuss further as a board, I think we should, if a board member has to leave, we need to reconvene for further deliberations.
Thank you. Board Member.
Member Duchess Harris, can I be recognized? And I finally have my camera on.
Yes, please. Excuse me. In response to Justice Meyer's request, I would simply state that just because a member is leaving doesn't mean the rest of the board members cannot continue to debate if that is the decision. And I will certainly ask that question before the question is called. Thank you, Board Member Harris.
That is what I was going to say. I was going to say that I've been a part of this since 9 o'clock this morning. But I teach from 3:15 to 4:30, and I do not feel comfortable canceling my class. If there needs to be discussion that happens without me, I understand that.
Thank you very much.
Madam Chair, this is Eliza Darris. I was actually going to make a motion similar to what Justice Meyer had just raised, just in terms of, feeling prepared to make the vote. A board member has to leave pretty immediately. We rescheduled this because one board member couldn't make a previous meeting. And so, I would probably most likely make a motion prior to our voting on the previous motion that's currently on the table.
Okay, thank you for the notice of that intent. I would ask that debate continue among the board members with respect to the pending question. The motion has been made and seconded that the board open the position of the Chief Public Defender in the 4th Judicial District for applications. Is there further debate, please?
Madam Chair, I recognize Herb Kroon.
Yes, Board Member Kroon, please.
Thank you. Several comments. I really want to thank all of the members of the public who joined this discussion, who've taken time out of their schedule to give input. That is very meaningful to me. I apologize. I'm the one that made the comment that the folks up there from the public were notified because of Mary Moriarty's Facebook post. That may have been one reason, but apparently there were several other reasons. Several other organizations also mobilized, and that is something that I paid attention to. I'm moved by what some of the line attorneys said about Ms. Moriarty, specifically the attorney that talked about how she helped coach him to prepare for his opening statement during the opening days of COVID. That struck home with me. But I also noticed that these are all line attorneys that spoke to us. I didn't hear from any supervisory, or we didn't hear from any supervisor attorneys, and that is also something that is meaningful to me. Third comment I want to make is there are ways to be an effective advocate and present a position forcefully, but with tact. And I think the concerns that we have are there are times when Ms. Moriarty does not make persuasive appeals with tact. And an example, most of the people that spoke today were very impassioned, and thought-provoking. One person was talking about how he would spit in Mr. Ward's eyes, and the conversation was terminated. I'm not saying that Ms. Moriarty ever said that, but I want everyone to understand that there's a different way that you can communicate. And there are times when Ms. Moriarty went over the line and went from being a personal advocate to being antagonist. And that's what we are concerned about. It does make a difference. Finally, salary dispute. The public should know that the board is very concerned about the salary disparities between the Hennepin County Attorney's Office and the Public Defender's Office, as well as salary disparities between folks out where I live in Mankato and the Twin Cities. We wrestle with these issues. They're important to us. So I think you all need to know it. Thank you.
Madam Chair. Thank you, ma'am.
Madam Chair.
Board Member Panetta, please. You're recognized.
Thank you. I would just like to comment. I've heard, impassioned pleas here. I do want to say one thing. I received 0 emails from people because if you didn't go to the public defense site to find my email, which is correct, I don't know why the email was incorrect. So I'm just saying there was some other site that people were using or some other information because I didn't receive that. That's a smaller issue, but I wanted to point that out. But more broadly, I wanted to talk about Mary. We heard people, they're saying things that are very true. Mary is an excellent litigator. I've sat through her trainings in the past. She's an excellent trainer, a good mentor, and what they say is true. But I don't think anyone really could fully understand what the position of chief in a state system. I didn't hear anyone refer to this as the 4th Judicial District. That's a minor point, but it's a different position than just the public position they're looking at. And if we don't reappoint Mary, she is still an excellent attorney within the 4th Judicial District, doing all her advocacy and all her training and all her litigation work that is important. I just wanted to point that out. This isn't about Mary having a job or Mary not having a job. It's about working within a statewide system of public defense, working with her colleagues, working with her supervisors. That's all I wanted to say right now.
Chief Braun.
This is Board Chair Braun, and I would like to just briefly state that I think some of the important issues from my perspective in terms of assessing somebody's effectiveness and ability to manage as a chief in the Hennepin County Public Defender's Office has to do initially with this presentation, this unauthorized presentation to the Budget and Committee, Hennepin County Budget and Committees Board. It simply was inappropriate. It was to my understanding and to I think many of the board members, it was planned, it was intentional. There were managers who spoke to that effect in the investigation. There has not been honesty about it. There has not been accountability for it. And I think it is a serious lack of judgment. And in the fact that there's no insight into that to this day, to this present time, is deeply concerning to me. There have been other issues that I believe reflect upon some less than honest comments to our board, specifically in regard to the expungement video. Ms. Moriarty had placed videos on the website with respect to clients' expungement hearings. And we had questioned her in that regard with respect to whether she properly obtained a waiver of conflict of interest from that client whose private and confidential information had to do with the expungement matter. She indicated to this board in at least 1 or 2 meetings that yes, she had it, that she would provide it, and she has never provided it. And I know that Board Member Lee mentioned this in the Personnel Committee this morning. I specifically asked her about that point. I know Board Member Kroon did, and to date, we have never received such a waiver. That's an ethical violation of her duties as an attorney. I think that it shows a judgment in placing the client in that position in the first place, and I believe there's been dishonesty about it, and I'm deeply concerned about that. With respect to the recent hiring freeze, I have an understanding from the public comment how particular individuals who are affected by that decision, how that would be a very difficult situation in a pandemic. However, this board offered a reprimand to Ms. Moriarty, and as part of that, she was not to make personnel decisions without approval or in consultation with the administrators. She did not like what she was directed to do, which was with respect to the hiring freeze. It's my understanding that there was an email to her subordinates complaining about the directive that she'd received, and then, as she described herself, decided to go to the county to solve the problem herself. And the failure to understand that that is in conflict with your supervisor's directive, whatever your motives, is again an inability to recognize her role and her need to have effective communication and relationship with her, with the folks that she works with on this board. It is in violation of our directive. There are other issues that I've previously spoken to, and I don't need to repeat today, and others have already mentioned, but I wanted to bring those issues to light.
Madam Chair, this is Board Member Lee. I was asked to be recognized for comment.
Yes, the chair recognizes you, Mr. Lee.
Everyone on this board and has worked diligently and passionately on salary disparity. We recognize how it affects and impacts our ability to recruit talented people and to retain them. I've worked directly with Mary. We met in my office with another one of her attorneys who is a good friend of mine, and worked, many of my law school friends wound up being long-term public defenders in Hennepin County. We had a direct line of communication to work on that. Somewhere along the line, I see this presentation and I'm pretty gobsmacked by it, because at any point in time before, I've always made myself available. I live in Hennepin County. Again, I have a close connection to the Hennepin County Public Defender's Office through multiple people I know. I take everything that we do on our initiatives very, very seriously. And the allegations of this, that, and the other thing, and, comments of that this is about ego, I really, it's really hard to hear that, because we are a volunteer board. I know that myself and committee chair Janetta have spent countless hours working on this particular issue throughout the entire, from the time we met with Mary on December 18th of 2019 through now. We've given every ounce. I was up at 2 o'clock in the morning reading emails that were coming through, not caring about what happens within our statewide system, particularly about our line attorneys in the 4th District, is really disheartening, but it's okay. People, this is an emotional issue. Mary's an incredible attorney. She's been an incredible advocate. But again, the position of a chief within the statewide system requires her to work within that system. And there is a hierarchy. You can't just supersede based upon your undisclosed intent and act on behalf of a statewide system when in fact you know, as the chief of the largest county in the state of Minnesota, that everyone knows that you are a representative of the State Board of Public Defense. You are acting always when you are a chief on not only behalf of your district, but on behalf of the entire statewide system. And there's just been an irretrievable breakdown. And I noted it during the Personnel Committee. The reprimand was an attempt to work through these things. And the continuing deterioration with threats of litigation when we merely followed up with seeking these waivers that are critical because these are the actual clients being represented directly by the 4th District office. And Mary very openly said, I have them on my desk and on my laptop, which is in my office, which I can't get to because I am currently suspended, but I will get them to you as soon as I am back in the office. And we waited and waited, and then we followed up, and we did get those waivers. And as discussed during the personnel, they were photo release waivers, not social media waivers. They required the signature of a witness, which, again, in an office of 120 attorneys and other staff and other members, there was no witnesses witnessing this signature on a release that doesn't cover exactly what was done with the very sensitive information. And then subsequent to that, just merely following up to get these, which Mary had agreed to give us, we get a letter from her legal representative, a notice of claims letter, threatening us with a lawsuit. I cannot see that she is willing to work within the statewide system, within the established supervisory roles that are established within the system to protect the integrity so that we can represent the residents of Minnesota throughout the entire state system. And that is my gravest concern, an ongoing concern, because it's never been addressed. I believe Chair Brown gave Ms. Moriarty an opportunity to address what mistakes you believe you've made. None addressed that. None addressed those issues of ongoing fulfillment of her obligations within the statewide system, which are beyond the 5 factors that have been outlined. They go with the memorandum of understanding, which she signed when she became Chief Public Defender of the 4th District. They go on with the general board policies for the State Board of Public Defense. So it isn't just the 5 factors that we have to evaluate her performance of her duties and obligations as a Chief Public Defender. And I believe that we've done so fairly and that we've done so diligently, and we've done so under the advice of legal counsel. And I just don't see that there is any indication that there's a willingness to work beyond these barriers which have been raised by her conduct and her performance of her duties. Thank you, Madam Chair.
Thank you.
Madam Chair, this is Elijah Darris.
Meyer. Excuse me, the chair recognizes Justice Meyer. I noticed that your hand is up.
Yeah, I want to thank everyone who gave public testimony today, and I really appreciate the clarification on how and why people came forth, because I didn't know any of that, and that matters to me. And what people said today really matters to me, because I have a context for what I'm hearing, and I also I wish I wish Board Member Harris didn't have to leave, because I wanted to have a further discussion with her about so this question of not having had job reviews is troubling to me. And she really brought that to light, and several people who spoke today brought that to light, and it's just troubling. And I find it to be somewhat persuasive. I also I'm just really struggling, because what I've heard today is just really valuable to know, and in the context of a vote, I was part of the personnel committee, and I'm concerned that I might have been persuaded otherwise. And I'm wondering, this is not a motion that's on the floor, but would there be an opportunity, and if no one wants to explore it, then I'll go with the board's decision. But is there an opportunity to extend the employment with some explicit understandings, and conditioned on certain things? For example, this potential ethical violation is a big deal. It sounds like a little deal, but it's a big deal, and I think clearing that up would be important. And maybe there's some other conditions that we could put in place. And I think it is really important, and it's our responsibility as a board to make sure that our employees are periodically reviewed. Because it's fundamental fairness, it really is. And would the outcome have been different? It's hard to say, but I just wanted to share my ambivalence about the vote.
Madam Chair, this is member.
Madam Chair, this is Eliza Darris. I've been in the queue for a few seconds here.
Thank you. I will recognize Mr. Darris.
If the gentleman will yield for a moment so that I can have the floor.
I will yield. I wasn't recognized, so I believe that it's the chair's decision on who is being recognized. I was just about to request to be recognized, so I do not believe I have the right to yield time.
Okay. Well, I got the little hand up. I'll take it down now if the chair is recognizing me.
Yes, sir. Please proceed.
Okay, excellent. Thank you, Madam Chair. Couple things come to mind. Board member Janetta stated that none of the communications that we all had received and that we all had been reviewing over the past month or more, Board member Janetta says she had not received any of those. And as the chair of the Personnel Committee, I find that particularly striking, in that some of those communications also came from justice partners, Chief Hutchison, among other major justice partners, as well as any community members. That really helps to inform the decision-making that we're having right now. So I find that particularly striking, and I do believe that, we should really pause and really look at making sure that we're making a fully informed decision, particularly from our personnel committee. It seems as though multiple pieces of information, including the cloudiness that seems to surround this issue of photo release, and it seems as though there isn't any finality to that based off of some of the comments that I've heard from Board Member Lee. And so based off of that, that also provides a level of uneasiness that I have with regard to us making, an employment decision when we have, this high level of cloudiness. I think that, I'm going to move that we table the motion in order to give time for more meaningful consideration of public comment and to provide any opportunity for potential mediation between Mary Moriarty and any board members or Mary Moriarty and Bill Ward, particularly in light of the lack of performance reviews over the past 6 years. And so we will be making a determination in the absence of, those performance reviews, which was part, the expectation for performance reviews is also laid out inside of our determination of this process from May 2015. And so the absence of that, the fact that that has not happened, again, to me is extraordinarily troubling and raises concerns, not just beyond, an upper management issue. It is, to me, it goes towards pure fairness of this process and making sure that, we are as informed and that we have as engaged and understanding of what the lay of the land is as possible. Certainly, if a board member has not been able to read any of the emails that all the rest of us have read, I find that troubling. Certainly, if we still have cloudiness around, what may or may not have been, and I believe there should be a level of finality to that before we make conclusions. And because that's not present, I find it troubling to make employment conclusions based off of, what appears to be, stuff that is still cloudy, and particularly in light of the resounding and pretty loud outcry from the community. I think that it might be important for us to table this. So I do motion that we table the affirmation motion that has opened up all of this discussion, pending further review and pending potential for mediation.
Madam Chair, this is Board Member Dan Lee. I would ask to be recognized to comment about Board Member Darris's just made motion.
Well,
I believe there is a motion, and I believe there is discussion on motions. You're on mute, Board Chair. Still on mute. Okay, there you go.
I'm working. Please give me one moment, please. There's a motion before the assembly. You're asking, for what point do you wish to be called upon or recognized, Mr. Lee?
Actually, my comments both address Justice Meyer's comments as well as Board Member Darris's comments and his motion to table this.
I would say, Chair Brown, just for a point of order, if the motion that I just put forth could be considered first before Board Member Lee moves on to other points.
Thank you. There has been a motion made. Is there a second? Hearing no second, the motion fails.
Can you state what the motion is that we're voting on?
There was a motion made by Mr. Darris to lay this entire issue on the table.
So, Chair Braun, could I restate my motion for clarity?
Sure.
Chair Brown, thank you. So the motion is for us to table the motion that we are discussing right now, pending our having an opportunity to have some further review in order to have a more perfected record. This includes allowing one of our board members to be able to review many of the emails that we've been reviewing over the past month. This includes us having a little bit more finality around what appears to be cloudiness with regards to a potential ethics violation. This includes, us, having a little bit more discussion around the lack of performance reviews over the past 6 years, particularly because those performance reviews was part of the contemplation in the May 2015 determination of what this process is. And so the absence of that, I feel troubled moving forward unless and until we can have more clarity around that and a few other points. But that's just, a more highlighted view of what my motion is to table the motion pending further review by this board.
Madam Chair.
Thank you for the clarification.
Madam Chair.
Excuse me, I'm hearing a motion to lay on the table. Is that correct, Mr. Darris?
That's correct, Madam Chair.
I'm finding that the motion is out of order at this point, as it really appears to be a motion to postpone to another meeting, which is not in order if it is designed to kill the main motion that's before us. So I would order that.
Madam Chair, I think it's designed to better inform the main motion. I feel as though many of us, there's pieces of information that's missing as expressed by other board members. And because of that, this is to better inform. And I believe that there's some fact finding and also some information gathering and some information sharing that's necessary. So it's to better inform the initial motion. And so that's the motion that I have that's on the table, seeking a second.
Yes, I recognize you, Board Member Janetta. For what purpose do you wish to speak?
I just wanted to clarify, saying I wasn't in the loop on all these and therefore it should be tabled. No, I have seen the correspondence. It's been presented to me. I was just pointing out that the email it was sent to is incorrect. I have seen all the material. I wanted to clarify that.
Thank you very much. So there is a subsidiary motion to lay on the table, which I have ruled is out of order. If the board members wish to have further debate on this issue, please advise. Otherwise, I would ask if you're ready to call the question. There is a motion pending before this board at this time. Are you ready for the question?
Madam Chair, Herb Kroon here.
Yes, Mr. Kroon, for which purpose do you wish to be recognized?
I just want to make a comment about something that Justice Myers discussed about some sort of possible mediation. I'm a mediator, so I'm all in favor of trying to work these things out. I am troubled by the lack of performance reviews, as is Justice Meyer, as are all of us. But I think that the letter that we sent her, the letter of reprimand, was in fact a form of performance review upon which she was given notice about what her behavior needed to be. And according to our staff, she didn't fulfill those obligations. Secondly, she can still reapply to be a public defender. So if she were to exert herself between now and when we make the final appointment to demonstrate to our staff that she can be someone that can be counted upon to be an active member and supportive member of the public defender staff of the state of Minnesota, she can do that. So those are my responses to Justice Meyer's comment, and I just wanted to make those known.
Thank you very much, Mr. Kroon. Any further debate on the motion pending before the board?
I just have a clarification.
Yes.
Justice Meyer again. performance reviews are not the same as investigations. This board conducted an investigation of potential malfeasance. We did not go out and seek to elicit positive feedback about Mary's performance. I mean, if it came through that there was positive feedback, but it was collateral to the main purpose of the inquiry. So I think a performance review is very different than what we conducted in January and February.
Thank you, Board Member Meyer.
Madam Chair, this is Board Member Lee. I've been asking to be recognized on this very topic that we're all talking about. So,
thank you. The chair recognizes Mr. Lee.
Thank you. I think one thing that strikes me today is that even though we've done and complied with all the legal requirements as advised by counsel, I think that the vote doesn't terminate employment, doesn't preclude her from retaining chiefship. As a part of the vote, it just opens up other applicants for the position. Ms. Moriarty would be able to apply for that. In the interim, she would retain her employment as a county employee. I believe a lot of the issues that Justice Meyer, which I very much respect, with regards to public input. I mean, I've listened to all the public comments today. This is a very important issue. Although we don't have to. Chair Braun, I think, made it clear earlier as a part of the motion is that after the vote on the motion, that there would be a public comment period as a part of any further action before we even took the next step in appointing either a new chief or reappointing Ms. Moriarty upon the opening for positions. So I believe all our concerns are addressed during that window of time. And I also want to address Board Member Darris's concern about these waivers being unresolved. They're not. The Personnel Committee has reviewed them, has copies of them, and has, I think, in large part, has made discussion upon that issue. And it is a part, at least a clear concern of mine in reaching my recommendation as a member of that committee. And I think in the interim, after this vote, I'd be, obviously we can clarify any issues with the rest of the board members on what the work of the Personnel Committee has been, which I think is important for the entirety of this board. However, I don't think that any of those things need to or should stop the vote that is on the table at this time.
Thank you very much. Is there any further discussion or debate?
Chair Ron, just question of clarifying question for Board Member Lee.
Board Member Lee, would you like to take the question from Mr. Darris?
Of course.
Sure. Thank you. Proceed.
I just want to be clear that the Personnel Committee asked for waivers to be sent to you all about, and I don't want to go too far down because I think it's a rabbit hole, but waivers to be sent from a client that appeared to be in a video, but the waiver didn't include social media as part of the waiver, but you were provided with a waiver of sorts. It just didn't have the fullness of the waiver. Is that clear? It didn't also state for social media. I just want to make sure I'm clear on the point that you're making.
Yes, that is a clear point, but then another clear point is that even the waiver that was given was not properly executed with that signature of a witness witnessing the client's signature at the time it was made, which is required as a part of even that waiver. So it was legally invalid on the form that was used. So those are the two issues.
Was there any discussion with the client themselves of whether or not they wanted to be in the video that was utilized, or is this a question of whether or not the proper process was put into place in order to utilize their expressly given consent, but not written consent?
All I can say is I did not have any direct contacts with the client themselves.
Are you aware of anyone else asking the client, whether or not they wanted to be in the video?
I don't know that again, our concerns are protection of the client's private rights to social media posts, social media information, and the use of their protected information to the public in the form of various forms of social media, because again, the client relies upon us as their zealous advocates, or the line attorneys as their zealous advocates, to protect their rights. And I think the fact that an improper or an ineffective waiver was used, the form was improper and ineffective to cover what the purpose of the use of that personal information, attorney-client information, was of the client, as well as the fact that it wasn't properly executed with a witness when you're dealing with an office of 120 attorneys and multiple other support staff. That seems to me to be a very simple thing to effectuate in an office of that scale and size on such an important responsibility that attorneys, public defenders, have to their clients under the attorney-client privilege.
Well, thank you, Board Member Lee. I am really troubled by the level of weight. What appears to be an oversight was given. I believe that, we should caution ourselves against placing such a high level of weight on what seemingly to me appears to be an oversight, in that one form of permission was given, not another, and it appears as though a witness wasn't also present. Is there a standardized formatted waiver that we have?
Mr. Derrick,
are you aware of?
you've missed the issue. The issue is with respect to attorney-client waiver of a waiver of a conflict, which she, Ms. Moriarty, represented to this board on a number of occasions that she obtained that she had a informed waiver of his consent, or his or her, the client's consent, and that she would provide those waivers to us. That has nothing to do with a social media or a website or a photograph waiver. It was absolutely a different waiver. So that's the issue.
Well, sure, Ron. I'm just referencing the multiple times that Board Member Lee has brought up that particular issues. It's been brought up several times now, and I'm just seeking clarification, because it appears as though there's a real high weight that's placed upon it, and I'm troubled that such a weight is placed on on what may be an oversight like that, or not an oversight like that, when we're talking about the potential removal of a chief public defender. So I just needed some clarification. I wanted the community and the public to also hear more clarification just in terms of exactly what we're talking about.
Yeah, and we aren't talking about oversight. We're talking about misrepresentation of something that she failed to do. Thank you. Is there any further debate on the motion pending before this board? Hearing none, I will call the question. The question is on the adoption of the motion made by Ms. Panetta that the board open the position of the Chief Public Defender in the 4th Judicial District for applications. For those voting in the affirmative, please say aye. For those in the negative, please say nay. Administrator Kyer will now take the roll.
Board Member Darris?
Nay.
Board Member Harris? Board Member Janetta?
Aye.
Board Member Kroon?
Aye.
Board Member Lee?
Aye.
Board Member Meyer?
Nay.
Board Chair Braun?
Aye. Thank you. The ayes have it, and the motion is adopted. There being no further business of this meeting, the chair would entertain a motion to adjourn.
So moved. This is Board Member Lee.
Thank you. The motion to adjourn has been moved by Board Member Lee. Is there a second?
Second. Herb Kroon.
Thank you. Board Member Kroon has seconded the motion. For those indicating in the affirmative, please say aye to the motion. For those in the negative, please say nay. Mr. Kyer, would you please call the roll on the vote to adjourn the meeting?
Board Member Darris?
Abstain.
Board Member Harris? Board Member Janetta?
Aye.
Board Member Kroon?
Aye.
Board Member Lee?
Aye.
Board Member Meyer?
Aye.
Board Chair Braun?
Aye. Thank you all. This has been a very difficult meeting, and I appreciate all your efforts and your everybody's comments and remarks. The board meeting is now adjourned.